the records have come. The learned district, they have dismissed the E&SC filed by the appellant on the ground that the will is suspicious. Will is suspicious. Or that
Which year is that?
alert
Which year is that?
2023.
Was this matter on 30th of September?
RTFC matter on the AFR consideration. A application.
Which year?
2023 matter. In some 10 months of not being posted. Already the recommend already filed.
No, the difficulty is court will add all those matters to the list. But whether the court will be able to complete the list or not is a question.
My lord, accusation petition is very next week.
2023, you people don't pursue it and suddenly everybody has urgency now.
My lord, FTP is pending, my lord.
Matter on 27.
My lord,
Defendant's appeal. Defendant's appeal. Ex parte defendant's appeal, my lord. MFA, my lord. Ex parte is granted 14 months ago, my lord. We are trying our level. Already, my lord, 8 judgments are in my favor, my lord. Between the parties, suppressing all this fact, my lord. Ex parte is taken. I work abroad.
What are you doing from 14 months?
My lord, we are moving vacate application all in the trial court, my lord. It has been adjourning, adjourn application ಹಾಕ್ತಾರೆ ಹಂಗೆ adjourn ಆಗ್ತಾ ಇದೆ sir. Change in the matter.
27.
My lord, FTP is pending in the trial court, my lord. We are seeking interim order in this matter. Seeking interim order, my lord. FTP is pending in the trial court, my lord.
What interim order?
First stay, my lord. FTP stay.
What are you questioning? What is the impute order before this court?
My lord, I don't know, my lord.
Which year is that?
22, my lord.
We'll see later. Yes.
Your Lordship, this is an enhancement matter. There is not even a rupee paid. Your Lordship had directed that as soon as the service of notice may be posted, service of notice is done 6 months back, Your Lordship. I moved couple of times, 2023 matter.
Yes, on 26.
Lordship, there's 2 MFA. It was posted for judgment on last date. This is the layout which was in question. There's a settlement between the respondent and the appellant, Your Lordship. The respondent counsel has sought time for seeking instructions. However, the matter is now posted on 30 of this month, Your Lordship. There is some development in the layouts which is going
We
on.
can wait. Can wait. Yes.
Lordship, this is 22 matter. Here, the petitioner husband has got a stay order on the maintenance order, which was given by the trial court. That needs to be vacated. So I has to be
When was the stay granted?
in the month of April. I don't exactly remember the date, but it was
Then there must have been an order, some conditional order must have been there.
kindly the matter.
Complying with it. Let's see. Yes.
Lords, we are challenging the order 39 rule 1 and 2, my lords. Therefore, my lords, can be taken up tomorrow, my lords. Any
Which year is that?
2022, my lords, and 2020, 22 and 20 as well, my lords.
No, all the urgency, this court cannot,
Apologies.
it's already see, every day there are about till the vacation, there are about 30-40 matters every day.
Any date may be given. Any date.
Court will give the date, add that to the end of the list on
Connect.
30th.
30th.
Yes,
End of the list.
page wise adjournments.
Page wise adjournment, list 1, page 1, serial number 1 to 4. Page 2, serial number 5 to 7. Page 3, serial number 8 and 9.
9, my lord, serial number 9, my lord, appearing for the appellants. There's some inconvenience, my lord. Kindly grant a week's time. Senior is not well.
No. Yes, next.
Page
Don't
number,
mention any of the old matters. Court is not going to grant adjournment and please don't ask for it.
page number 4, serial number 10 to 14.
But 12, my lord. 12. Need
Yes.
3 days account.
Why?
No, translated copies are given papers for translation. All the
No,
documents.
why? What for these cases are listed? I'm not able to understand.
are given in the paper.
You have a
2
stay
days
in
ago.
this? There is a stay in your favor?
No, there is no stay.
Then what is the purpose? Why MFA of 2022
I'll
will
place
be
the
pending till
translate,
now?
Otherwise I can't convince.
What is a translated copy?
Lord, the plaint itself is in Kannada.
If whether it is required or not, we'll see.
Please.
Whether the court wants to see the plaint or not.
Page number
Yes.
5, serial number 15 to 20. Page 6, 21 to 27.
Serial
Page-
number 21 ಮೇಲೆ
Yes.
ಸೀನಿಯರ್ ತಂದೆ ಹುಷಾರಿಲ್ಲ ಮೇಲೆ ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ 2 weeks time.
And for the respond number 1 to 4, lords.
Stays there.
ಇಲ್ಲ
Stay not there. Stay. Admission.
Suppose this matter on anybody who asks time, it will be a long date. Please first think that and then mention. Both
My
matter
lord, one submission.
November 4th.
17th may be lordship because FDP is there in trial
There's no
court.
interim order. Whatever you want to do, you do. Yes, next.
Please, much obliged.
Yes. Pose this matter on December 16th at the request of Lanka. You appear for whom?
27, respondent.
Yes.
Harini Shivananda,
Have you informed the other side?
Yes.
Yes.
page number 7, say number 28 to 34.
31,
Hmm.
I'll be here at 2:30. I'll be here at 2:30.
Yes.
Page number 8, say number 35 to 38.
33.
The man is below, the value of the property is below 10 lakhs. So I'll be filing the appeal before, Kundapura Senior Civil Judge.
That's a basic thing. Even before filing the appeal, the jurisdiction of the court. A memo is filed seeking to withdraw this writ petition. It is submitted that the appeal is maintainable before the senior civil judge, Kundapura, instead of that he had filed an appeal before this court. Accordingly, memo is taken on record and the appeal is dismissed as withdrawn with the liberty to file an appropriate petition for the appropriate court. But the registry shall return all the records to the petitioner. Yes.
Liberty.
Huh?
Tax paid here may be.
Once the court grants liberty, that means that court has given you that, yes.
Sale number 8, sale number 35 to 38. Page 9, sale number 39 to 45. Page 10, 46 to 49.
49, my lords. It will take up tomorrow, my lord.
Which one?
49. So final hearing matter tomorrow or day after, my lord, otherwise I'm tied up at
Tomorrow,
court on
day
number
after
8.
tomorrow, it's not possible.
Day after tomorrow. one.
Not possible. There is the
Date may be.
the board is heavy. Post this matter on October 15. Yes, at the request of land council for the appellant.
This
Yes.
one,
My lord, so my
Copy.
list 3, my lord, list 3, say number 24, my lord, am I permitted to withdraw, my lord?
20.
List 3, 24, with the liberty to, my lord, approach the court. my lord.
So liberty cannot be granted at the time of mentioning. Court has to look at the file, what liberty you are seeking.
No, my lord, say you have to file a pecuniary jurisdiction, I need to file
We will
the,
see, we have to look at it, we have to look at the file. You please mention it in the 2:30.
please.
Yes.
page 1. Sale list 1, list 2, sale number 1.
For the petitioner, my lord.
Nagaraj R. For petitioner.
Respond in the matter.
Yes. Yes, where is the
My lord,
application?
The first petition that I would like to take your lordships through is writ petition number 23642 of 2024. That's the main matter. My lord, this particular petition, I have filed challenging
Is this,
the,
which is? Yes, yes. Which petition has to be looked into?
my lord, 23642.
Yes.
Yes, my lord. In this, my lord, I have challenged a certain order dated 28/2024 that your lordships may find at page 17 of the petition.
Yes.
My lord, this particular order, it comes to be passed on an application that is made under order 18 rule 17, seeking to recall the stage of cross-examination that I've produced in annexure B, page 20. And a similar application comes to be made in page number 22. That is also for recalling and reopening the stage of cross-examination. My lord, the issue at hand is that this particular, the impugned proceedings, my lord, it's a GNWC petition of the year
So when is
2020.
the examination completed?
My lord, the examination is still not completed. The cross-examination is it's still not completed by the opposite parties before the trial court. My lord, the issue at hand is that since considering that the case,
The PW1's cross-examination is completed.
my lord, the PW1's cross-examination is not completed in this yet. My
And
lord.
then what is the difficulty for you?
My lord, here the difficulty is, my lord, the case the
What you
impugned
have to
proceedings.
understand is you want a timely disposal.
Yes, my lord.
No, unnecessarily by filing these kind of writ petitions, you are in fact, you are stopping the court from disposing of the matter.
No, my lord, let me just place one submission here. is that, my lord, here I had already about this, the impugned proceedings is of the year 2020. And considering considering that the trial court proceedings have been pending for the last 3 to 4 years, I had already approached this honorable court wide writ petition number.
There was an order.
Yes,
there
my
was
lord,
a
there
time
was an
frame.
order.
No, the court had asked for extension
Yes,
of
my lord.
time.
Yes, my lord.
Yes, then
My lord, here the issue is, my lord, the conduct of the respondent in seeking frequent adjournments. My lord, kindly allow me to take your lordship through the docket proceedings.
it's all waste of time now. No, the court had sought for a time
Yes, my lord.
from this court.
Yes, my lord.
Court has granted it.
Yes,
And
my
the
lord.
court is bound to complete the trial within that time frame.
Yes, my
So
lord.
why are we hearing all this, wasting the court's time?
My lord, the issue is with regard to the frequent adjournments that are being sought for.
Now that issue, you can't raise that issue now because there is an order from the court.
Kindly,
The
kindly,
court
my lord.
will go ahead with it.
My lord, let the cross examination proceed. All I ask now is that if your lordship may be kind enough to fix certain dates as to when the cross examination has to be
The High Court
completed.
has no other work but to fix this schedule of the lower court, please.
My lord, then again, my lord, one more issue that needs to be looked into.
No, your case do not require any special attention from this court. No, there
My
is already special attention given and there is an order passed of a,
Yes, ma'am.
your MC is of the year 2020.
Yes,
And
ma'am.
in that you are given that your MC has to be disposed of within 4 months or 3 months.
Yes,
So
ma'am.
the court has sought for time. Let the court do it because this is not one exceptional case where the court has to, every time come to the rescue of your client and fix what the trial court has to do, when it has to do, how it has to do.
Kindly, my lord. My lord, then again, my lord, the impugned application itself, my lord, the trial court itself has noted in the order in the docket proceedings that the respondent wife is trying to drag the proceedings on several occasions. And despite her conduct, despite the demeanor of the respondent in trying to delay the proceedings and drag the proceedings unnecessarily, an application comes to be filed. A vague application comes to be filed without giving out proper reasoning as to why
Not able
the
to
stage of
understand
cross-examination has to be recalled.
Not, we're not able to understand one thing. Now, at this point of time,
Yes.
opportunity is not given. When a final order is passed, again, they'll come to this court and will come, while looking at it, if the court feels that the property was not cross-examined or opportunity is not given to him, again, the matter is remanded. Is it not waste of the time and your time?
My lord, no, one more factor that needs to be taken into consideration is that the stage of cross-examination, wherein my cross-examination had to was commenced back in the year 2022 22 itself, my lord. For the last 2 years, I've been under cross-examination.
The court has already indicated its mind that it's going to dismiss your writ petition. Why do you unnecessarily labor on that? Please come. What is the next petition?
My lord, the other petition is with regard to the MC petition. 236.
Same,
No, my lord, one was GNWC petition, the other is MC petition.
What is the order in that? Same order?
Same order. Same, it is the same, it is the
IA
same
number
situation.
18 and 19, you filed two different writ petitions?
Yes, my lord.
Yes.
it-
Agreed with the orders passed.
My lord, if I may place on record,
Can I objection? 2 minutes, I know that I should not labor on this, but the party who secures an order from this court in direction would not bring to the notice of the trial court. He takes the order from this court, he retains with him, and for 4 long months it was retained with him. He did not whisper anything about that have taken a direction. It is on from this court, an order is dispatched to the family court office. A family court office put up a note in order sheet saying that this is direction. Only
Yes,
the trial court
the,
takes it out.
both of you, not necessary. no? IA number.
Taken record.
Take
my
the
lord,
IA
if I
number.
may place on record a judgment, my lord. This is with regard to the applications that are being filed without
Want
giving
me to
out
take the
proper.
judgment on record? I'll now dismiss it with exemplary cause that you're wasting the court's time.
My lord.
IA number, IA number, agreed with the orders passed in IA number 18 and 19. And in GNWC number
113 of
13 of 2020 and MC number?
MC number is 1537 of 2018.
Huh?
2019.
And 24475 of 2024. The husband had filed MC number 1537 of 2018, seeking divorce on the ground of cruelty. And he had also filed GNWC number 113 of 2020, seeking custody of his minor children. The
Cross-examination.
The petitioner had earlier filed WP number 20675 of 2023, wherein a prayer was sought for expediting the proceedings in the GNWC and the MC. On 14/2/2024, a coordinate bench of this court had disposed of the same, directing the trial court to wrap up the proceedings within a period of 4 months. Why you have filed another, that is with regard to GNW?
Yes, my lord.
And with regard to the other proceeding also, WP number 10, in respect of both MC and JNWC, has filed two writ petitions.
Yes,
One is WP 20675 of 2023, and the other is WP number 10501 of 2024. There was a direction by this court to dispose of the matters within a period of 4 months. Now, it is a grievance of the petitioner that on one pretext of the other, the respondent is dragging on the matter, and the trial court is also granting time liberally. The order that is impugned before this court is an order in I number 18 and 19 in both the cases, where the wife had filed an application
And
under
one small
order
correction, my lord. In, with regard to petition 24475, it is I number 19 and 20.
I number,
19 and 20. With regard to 24475, it's I number 19 and 20.
it's a I number,
19 and 20.
here it is 18 and 19.
Yes, my lord. In the GNWC petition, it is 18 and 19. In the MC petition, it's 19 and 20.
GNWC, I number 18 and 19. In MC petition, it is 19 and
20.
Date is same.
Yes, my lord.
The filed an application under order 18 to 17 CPC and sought permission for further cross-examination of PW1. It is stated that the petitioner that the advocate was not keeping well and could not proceed with further cross-examination of PW1. And if the applications are not allowed, the wife will be put to hardship and requested to allow the application. The petition herein has raised his objections and also had brought to the notice of the court the order that is passed by this court. The trial court had allowed that application, and while allowing the application, the court had observed that the petition is filed with the husband declaring that he is natural guardian of his children and also for permanent custody. The wife had filed strong objections and made several allegations. In this situation, if the applications are dismissed, the wife will be put to more hardship and injury. And as according to the respondent wife, she is ready and willing to join matrimonial home. Further, the respondent is taking care of the well-being of her children. Hence, there are no grounds to reject the application. And court has also observed that the husband is having every right to put his defense against the respondent by way of cross-examination. And accordingly, the court had allowed the application and posted the matter to 28/8/2024 for further cross-examination of PW1. Aggrieved thereby, the husband is before this court. When this matter came up before this court, it is submitted that in spite of an order before this court, by this court, without seeking extension of time, and without seeking extension of time, the learned judge is liberally granting time to the respondents. And this court has called for a report from the learned judge, where a report is placed before the court stating that there are several pending cases, and where in some of the cases, the time frame is already fixed by the trial court, by this court. And due to the workload, she could not complete it. Then on the next occasion, this court had asked for another report. Why the why she has not sought for extension of time when a time frame is fixed by the court? A report is placed before the court stating that she has already sought for time and she has addressed a letter. Considering, addressed a letter. Then the matter is posted today for hearing. Learned counsel for the petitioner submits that the respondent is dragging on the matter. The court on several occasions has observed that the respondent is not proceeding with the matter. In spite of that, the application that is filed by them is allowed. Next paragraph. No, same paragraph is allowed. He submits that the court ought not to have granted the adjournments to the respondents and ought to have proceeded with the matter. Now again, by virtue of this order, the matter would be further delayed. And as per the timeline fixed by the court, the court will not be able to complete the hearing. Next paragraph. Learned counsel appearing for the respondent submits that. What is your name? Your name is not reflected.
Mallikarjun or
So and so, then counsel appearing for so and so submits that. The order that is passed by the court to dispose of the matter expeditiously within a time frame was not brought to the notice of the court. He submits that they're ready to proceed with the matter. The trial court, considering the difficulties expressed by the respondent, had rightly passed an order and no interference is called for with the said order passed by the court. Next, having heard the counsels on either side, there is a material on record. This court had already exercised the discretion and passed an order. Issued a mandamus to the trial court to dispose of the matter. This matter is pending before the principal judge, family court by Bangalore. Looking at the report placed by the learned judge is already burdened with several cases. And in 11 of the cases are already time frame is fixed by the court. In the process of disposing the matters in a time bound manner, the courts also have to consider the interest of the parties. Time alone is not the criteria, but they'll be able to ultimately the substantial justice will be delivered to the parties. And when the matter is placed before the court, and the court exercising the discretion has felt that this is a case where unless an opportunity is given to the wife, it would cause prejudice to the wife. In the considered opinion of this court exercising the jurisdiction under Article 227 will not interfere with such a discretion exercised by the learned judge. Next para. However, the judge has already addressed a letter to this court seeking further time for further time to conclude the proceedings. And as per the set time frame fixed by the court, the trial court shall dispose of the matter. The respondent shall cooperate with the same and shall not seek unnecessary adjournments. And as fixed by this court, as fixed by the time frame by this court, the respondent shall also proceed with the matter. Accordingly, both the matters are disposed of. Yes, next.
List number 1, still number 1. Preliminary hearing.
What is this memo for retirement of the counsel for the petitioner?
That's the previous counsel, Mr. Pritesh D'Souza, my lord. I appear for the subsequent advocate who filed the admission.
Yes.
Lord, it's against a GNWC order, my lord, where the honorable court has granted me permission to visit the kids on every first Saturday of every month in the mediation center in the Chitradurga, my lord. Order was passed in the year 1922, my lord. But till date, she has not complied the order, nor she's allowed me to meet the kids on the first Saturday of every month, my lord. Though I've been filing memo before the honorable trial court in Chitradurga telling that the order has been passed, she is not getting the kids to meet during the mediation time on the first Saturday of every month. From 2018 till.
What is the order impugned before this?
My lord, page number 34, my lord. My lord, the petitioner is permitted to meet the minor children on.
No, 2022 order, how do you challenge it now?
No, my lord, we are asking for modification of the order, my lord, where they have
That's
granted.
why you're asking it now, 2022 order.
No, my
If the
lord,
same order, if you want any other order, you can file an application before the court.
there we have filed an execution also. my
No,
lord.
this forum shopping should be stopped.
Uh,
2022, you have an order. Why should you come before this court in 2024?
My lord, we are asking for modification where I may be permitted to visit at least 5
But
days.
then that modification, let the court pass orders. Then why should, after seeking a modification, again, you can't seek a modification of an order of 2022.
I'll make a necessary application, my lord.
Yes, please come.
My lord, kindly it be maybe called next week, my lord. I'll seek instruction and make application or I'll withdraw the petition, my lord. It may be called next week, my lord.
At the request of land council, the petitioner pose this matter next week, next Monday.
Cell number 2. Rashid Khan, for petitioner.
Okay, for the petitioner, madam.
Hmm.
Weeks time may be granted, madam.
Why?
Senior is not feeling well.
Huh?
My senior is not feeling well, madam.
What is the impugned order? For admission also, why senior is required? You have the papers, please take out. When is the order? Yes.
Annexure J, madam. Interim order, madam.
Hmm.
Annexure J.
Applicant respondent is entitled for interim maintenance of 30,000 per month and one-time mitigation expenses of 25,000. Oh, she has come before this court for enhancement.
Yes, ma'am.
Notice to the respondents. Petition is permitted to take out hand summons to the council appearing for the respondent before the trial court
Cell number
and
3.
shall file a memo to that effect. Shall file a memo to that effect by 30th. List this matter on October 16th. Yes.
Cell number 3. K. Abhinav Anand.
Yes.
Please, my lord. The divorce petition filed by the husband in the year 2017, my lord. And he adduced his examination chief.
What is the relief you are seeking?
I am praying for direction to the family court, my lord, to conclude the matter. 2017 matter, more than even for the length of 5 years, my lord. Cross-examination of PW1 is not concluded.
Please come. Who filed the MC?
Husband's petition.
Husband had filed MC number 1369 of 2017, seeking divorce. No, before that, the present petition is filed seeking a mandamus, directing the trial court to dispose of the pending MC number 1369 of 2017 as expeditiously as possible. Then council submits that the MC is filed in the year 2017 and right from
Right from 10/1/19.
10/1?
10/1/19.
10/1/19.
19
There is
till
no
date,
progress.
cross-examination of PW is not over.
There is no progress in the case and the cross-examination of PW1 is not concluded. He submits that. That the matter is pending the last 7 years before the court. on one pretext or the other, the respondent is dragging on the matter, and the court is also granting adjournments liberally. And there is no progress in the court, considering the submission of the Land Council and looking at the proceedings of the trial court. As this MC is of the year 2017, this court deems it appropriate to direct the trial court to dispose of the matter as expeditiously as possible, but not later than 6 months. This court is not issuing notice to the respondent, as disposal of the case is in the interest of both the parties. Yes.
Case number 4, parted matters. Harshvardhan. For petitioner.
Pay for the
Shobha.
petition.
Yes,
My lord, kindly, there is an order dated 19/3/2024, my lord.
take it at 2:30, both the matters. Yes, next, come to preliminary hearing.
Case number 5. Preliminary hearing regroup. Case number 5.
My lord, I appear for the petitioner, my lord.
Yes, Umesh.
Yes,
My lord, before starting, my lord, I would like to bring to my lord's notice that is one MFA is pending on the main matter, and my lord, the respondent has appeared in the other matter. My lord, if my lord feels that it could be posted along with that would be fair. Otherwise also, my lord, I am ready.
why should it be posted along with it?
My lord, that is the main matter, my lord, is the
Okay, main matter is on something else.
Please,
This
please,
is
my
on
lord,
something
she has,
else.
no, she has appeared there, my lord, that is why I said.
Yes.
Otherwise also.
Yes, what is the matter about?
My lord, it's about the litigation expenses, my lord.
Yes,
My lord, the petitioner is working as a teacher, my lord, and earning 5,800.
how much is granted towards litigation expenses?
1,000 per month, my lord, until the petition is pending. And my lord, you will actually kindly see, 5,834 is the salary. He is already paying, my lord, maintenance of about 9,000 rupees for
Respondent
the
is
child.
Respondent is served.
Respondent.
Yes, my lord.
Yes.
That is why I said, my lord, the matter is before the.
No, if she is served, she is not come out.
Yeah,
she is
I
not
leave, I
appearing
leave to,
before
I
the court
leave it to my
without
lords. I
appointment.
know.
Please come to the order. Where is the
Yes, my
order?
lord. Annexure,
Uh,
my lord, page 86, my lord. Unfortunately, my lord, there was some problem and we could not file statement of objections to the IA.
Which page is the order?
My lord, page 86, my lord.
86.
Yes, ma'am.
I think 86 is not the order.
85, 86 is the IA5, my lord, order on IA5. Last election, my lord, I'm sorry, in the paper book, last document, my lord.
What are the reasons given by the court? Please come to that.
My lord,
Come to the reasoning part.
yes, my lord, in the para 2, my lord.
No, come to para 7.
The petitioner husband has filed this petition for divorce. This is transferred case from the court of Ajmer, state of Rajasthan. Now the case is reached the stage of arguments on merits. At that stage, the respondent counsel has filed the above A for
No,
recovery
she
of.
has to, every time she has to come from Ajmer.
Milad, I did not want to go to the details. Milad, I had filed the petition in Ajmer. She went to the apex court and got it transferred to Bangalore. She went to the apex court, Milad, and got it transferred. There are number of claim petitions filed, not one. Milad, one case, Milad, in criminal NISA, I produced all
No,
those.
she is a resident of Bangalore or Ajmer?
She is a resident of Bangalore. She got it transferred, Milad. From Ajmer, she went to apex court. Milad, she is a model. earning more than, my lord, 25 to 30,000 rupees per month. He is a school teacher, my lord. And the maintenance, as a husband, my lord, is bound to maintain and the maintenance order. I have no qualms with that, my lord. Even then, the litigation expenses per month, unfortunately, my lord, I could not file my objections to this application because of some papers were to be sent to Ajmer and got back and all that. Now, my lord, may kindly see the other two orders, annexed C and D. In fact, in one criminal matter, the court has refused to grant my litigation expenses. Unfortunately, we could not bring it to the notice of the court, my lord. That is why, my lord, I said if it could be tagged along with the main, I could be able to. Annexure C and D will kindly be seen. Those are the orders in criminal matters. I have produced my salary certificate.
How much you will pay one time?
My lord, may I request for some time, my lord, I will put it across to them and find out what could be the reasonable amount.
18 matter. How many times?
I
it
know.
has come up
My lord,
before?
now the matter is over, my lord. It is before the High Court now.
You please get instructions. I'll try. I'll pass
I'm
over.
obliged, my
Every
lord.
day,
I'll
every
be
day the
grateful
court
to,
can't,
I'll be grateful to.
pass over. Yes,
My
next.
lord, he is in Ajmer, my lord, a week's time may kindly be granted.
Then we'll pass an order, whatever the court feels. It
I
has
leave
to
it
be
to-
either ways.
I will leave it to
You
my
please,
lords.
yes.
I leave it to my lords. That is the difficulty, my lord.
The will grant 30,000.
My lord is already paying so much of, my lord,
How much he has
maintenance
paid
and
till
all.
now?
My lord,
You appear
10,000.
for the respondent?
Sorry, my lord, next matter, my lord.
Yes.
10,000, my lord.
I thought your lordship was adjourning the matter, so I would tell him sorry, my lord.
How much you must have paid by this time?
My lord, already several, my lord, maintenance is being paid, my lord. There are several criminal, my lord may kindly see, she is capable of reaching Apex Court, my lord, and get it transferred to Bangalore. This may kindly be considered, my lord.
But you are capable of keeping this matter pending from 2018 to till now.
My lord, the matter is posted only last time I took time.
Listen, agreed with orders passed in I number 5 in MC number 745 of 2014 dated 16 January 2018. The husband is before this court. The court had granted an amount of rupees 1,000 per month to the wife towards litigation expenses from February 2014 till the disposal of the petition. In this case, the notices are served on the respondent and no wakalat is filed on behalf of the respondent. Learned counsel appearing for the petitioner submits that in fact, the matter was, in fact, he has instituted the MC before the courts at Ajmer, Rajasthan on the application filed by the wife taking transfer, that is transferred to Bangalore. He submits that the petitioner is a teacher.
What? Yes, ma'am.
And his earning is
5,836. I'll give the exact figure.
His income is
About 6,000 rupees. 5,836 is the amount.
His salary is
You may not
5,000.
may say 6,000 rupees. 5,845 to be precise.
6,000 rupees.
5,845.
His salary is around 6,000 rupees. He submits that. In that now, the order of the court is right from 2014. The petitioner has to pay 1,000 per month to the wife towards litigation expenses. The said amount granted with the court is without any basis. There cannot be a monthly litigation expenses. And that too, considering the salary of the husband at 6,000. Then counsel submits that that he has been paying the amount as ordered by the court. And the learned counsel of the petitioner not submit what exactly is the amount that he had paid so far.
No, Milad, sorry, I did not say that, Milad. As far as that, I have no knowledge. Milad may.
He submits that
there is,
he is
yes.
not aware whether the said amounts are paid
Yes, ma'am.
to the wife or not.
Yes, ma'am.
This court, having heard the counsel as per his order passed by the trial court, the trial court ought to have granted some amount towards the litigation expenses considering the salary of 5,000, 6,000, around 6,000 of husband, granting an amount of rupees 1,000 from 2014.
There is
month.
already an
It's
order
not-
for maintenance, my lord, which we are paying.
It's
3,000
not,
for the
to be
child and
considered
3,000.
order. He's
And
also
3,000 for
saying
the
that
child and
apart from
3,000.
this, he's also paying the maintenance to the wife. Considering all this court deems it appropriate to modify the order and respond, petitioner husband is directed to pay an amount of rupees 30,000 towards litigation expenses.
My lord,
Yes.
may I persuade, my lord, can it be reduced a bit, my lord? In fact, he is, my lord, trying to, he has filed.
This order is sustained from 2014. Per year it will be.
I am aware of that, my lord. I am,
12,000,
my lord,
12,000 into
I am
10
only
lakh.
making an effort, my lord, kindly see, she is a model.
Let it be 30,000.
Yes.
Yes, next.
I leave it.
6, E package for petitioner.
But I appear for the petitioner in this matter.
Yes.
But this is a,
Kindly permit me to file memo. Petition has become infructuous.
Take that also.
That's it.
What is the order impugned?
but the order impugned is order with respect to not permitting us to celebrate the second birthday of the child at Hyderabad. That of course, was passed on 23. Now the child is 3 years and 5 months old or 6 months old now. And
But this matter is not disposed of.
this matter is not disposed of.
Yeah.
The other application,
There were 3 or 4 writ petitions filed between the same party regarding the interim arrangements. On the last occasion in the connected matter, your lordship has given all the liberty to. raise
I
all
think in all these matrimonial matters, you give a chart. When are the important days? So on every day that even before you ask, the court will pass an order that today you take her there or you come from here to there. How much time the court will spend
Yes,
on these
I
things?
know, Milord.
The other day, they've argued that
I know, I
order is passed.
Seen the order.
No, again.
This one was there at that point in time. It's that petition was still pending. This petition, Milord, is only celebrated the birthday of the child. At least now, Milord, when
When
Dasra
is
has
his
come.
birthday?
Birthday is over, Milord. This year also is over. Last year also is over.
So what remains in this?
We can celebrate later is what we had stated.
He's having access.
He'll already
Whenever he has access, let him celebrate.
But I know, Milord, now the difficulty
So
is,
for him,
yes,
if I remember, apart from court has even considered the eventuality of a fifth Saturday also. That's also been taken care of.
yes,
Is
yes,
it-
that order. Well, your lordship's order, Milord, is very comprehensive. It covers all these things. But we are only making a request now because, Milord, Dasra vacations are coming. At least, Milord, for 1 or 2 days, we'll take the child to Hyderabad to meet with the mother.
I think let's not.
He's filed
Again,
an application
this is
in
a
the
final
family-
order.
Milord, we filed,
When
no,
he-
no.
When he should approach the trial court also, I think that.
I
that
filed an
guidance will
application
be-
there. 7 hearing dates have gone by. No order is passed. No objections are filed by them. They are also not. I understand, not one can say, oh, this is all very technical in arguing this and coming before your lordship's one and arguing for something else.
It's not about technicalities. In fact, the court had given anxious consideration and passed orders.
Yes, Lord,
Now,
I
on this
completely see.
petition, let's not, let there not be any order.
Then can I only make one request, Lord? Would your lordship only direct the trial court? There is an application that we filed for vacation and other, which is as
What
per
is
your
the
lordship.
IA?
What is the IA number? That application
Last
notice.
occasion, they took time saying that counsel is on maternity leave.
No, but you haven't even filed objections. Yes, she's on maternity leave is the truth. That is true.
File.
No, objection not filed, madam.
See the matter, sir. You could have argued the matter. Press the matter.
We'll move it.
What are the IAs?
IA number.
IA numbers?
IA number 16. 16, man.
16.
IA 16.
There are other IAs also filed, let all the IAs be considered with the.
So that vacation IA let it be considered, Lord. All I'm asking is ultimately.
What are the other IAs pending?
The other IAs. He only has filed all the 2 or 3 IAs. All the applications.
No, there's some application filed to restrain us from going.
So you don't ask for all the IAs. What IA they're asking, only that we will dispose of. IA number 16.
16.
Please come.
Seeking vacation, vacation.
It's vacation. The present petition is filed.
What-
Question the order dated 29/3/2023 passed with the second additional family judge Bangalore on I number 10 and JNWC number 3 of 2022. Dated 29/3/2023.
Lord, let me do one thing, Lord. I don't want your lordship to unlessly pass an order and spend time on this. We'll withdraw this writ petition with the direction, Lord, to dispose of that application, which is pending.
No,
So that,
that only I'm going to do.
I know. Okay.
To say why you have come before the court, at least that has to be stated.
Yes, yes. I thought your lordship was passing a detail.
to, and consequently allowing the petitioner father to celebrate the second birthday of the minor child at Hyderabad belatedly. This application is filed in the year this
23.
petition is filed in the year 2023. No, it is stated by both the parties that the birth and even the 2024, now the 2024 birthday of the boy is also now over.
They celebrated the birthday.
It's also celebrated by him.
It was
It's celebrated by the
Bangalore.
father
Because
in
not-
Bangalore.
Grandmother had to
Bangalore
wanted
instead
to
of,
see this.
no, I think I also remember
Lordship,
one
I love-
Hyderabad, the episode is also over, where they want to go or the grandmother wants to
Grandmother
come
came here.
That's last time your
Yes.
lordship.
On
did.
Lord wheelchair, she came to Bangalore and some consideration my learned friend can have, my lord, for us as well. I'm only saying, ultimately, what appropriate age, the child is happy with the father.
Already celebrated in Hyderabad and in Bangalore. Then counsel appearing for the respondent submits that already this court has passed a comprehensive order. In WP number, what is the number?
12734.
I filed a
12734.
12734 of 22.
1274734 of 2022 by order dated 18/7/2024, and no further orders needs to be passed in this petition as it has become infructuous. Then a senior counsel appearing for the petitioner submits that in fact, IA number 16.
Application number, my lord, I'm not sure. I'll leave
An
it to the court
application is
office.
filed seeking what?
Application
All
filed
the
seeking
holidays.
for
Holiday
holiday
visits.
visits.
Has filed an application seeking the visitation during holidays and a permission to take the boy to Hyderabad.
Yes.
And a permission to take the boy to Hyderabad, hence, and the matter that IA has undergone several adjournments. And there may be a direction to the trial court to dispose of the said pending application. Next, considering the submission of submission made on behalf of both the parties.
When does this
And
start?
the fact that this court has already disposed of WP number 12734 of 2022 dated 18/7/2024, comprehensively looking at the requirements of both the parties. This court deems it appropriate to dispose of this writ petition directing the trial court to hear the pending IA with regard to this holiday visitation as expeditiously as possible.
And before Dasara vacation.
Before Dasra vacation.
Before,
Yes.
I'm great.
Cell number 7, Raghupatad BS for petitioner, Ganapati for respondent.
Time for the respondent, due for the petitioners, my lord. Challenge to the execution proceedings, my lord.
Mm.
Contention only raised is with regard to the limitation.
No, 1 minute.
Yes,
I think all these matters have come up earlier.
yes,
also.
yes, my lord.
Then I said
Fact,
that.
Yes,
there's a
the
judgment
Supreme
of-
Court judgment, my lord.
Uh,
Yes, I verified, my lord, even the latest division bench of the Delhi High Court also. It says even if it is barred, they can file a civil suit. But that itself would not absolve my liability. The division bench says if though one
No,
25(3),
don't go to the division bench judgment. What did the Supreme Court?
Supreme Court says, my lord, that it
That,
continues.
that limitation will not apply.
Yes,
It is your continuous.
my liability
responsibility.
continues.
Uh,
My only apprehension now is, my lord, this is filed, my lord. Some facts, my lord, we are separated since 25 years now.
We'll just see now, 1, 2, 3,
Yes,
4.
for
Like,
4 years, they have
4
filed
years.
4 different petitions.
You question that 4 execution petitions by this writ petition.
By 4 different writ petitions I have filed.
Uh,
The facts, my lord, we are separated since 25 years now.
Hmm.
I filed restitution, notice went to her, she did not respond. Then I converted my petition to divorce petition, divorce was granted.
Alimony was granted permanent.
No, she did not appear before the court. She filed written statement, abstained from further proceedings. Then, my lord, she filed an appeal directly to this honorable court. Matter was remanded. My judgment and decree where granting of divorce was set aside and remanded for fresh consideration. Pendency of that, she filed for the first time the application for maintenance.
No, she wants maintenance now that we cannot deny.
Now, my lord, the son, she separated when she was pregnant and she did not return back to the matrimonial home. The son has attained 25 years. So he is earning. Now the only intention, it's not that she requires this amount for her maintenance. She is more well off than me. I am only at railway ticket collector, or rather now I'm a ticket inspector. My lord, they have got innumerable properties. Even though she does not approach, every time her father approaches my senior officials complaining that there is a petition, they had filed 498A.
That order of maintenance.
Yes, that maintenance was not challenged by the earlier.
So
That
you
is the-
cannot question all those things.
Yes.
which are on the
In
manifesto.
fact, we have challenged before the division bench, my lord, the divorce proceedings, which was dismissed, which I had filed. Now, my lord, though, my lord, I am liable to pay, now I cannot challenge these aspects now in view of the Supreme Court judgment. My only endeavor would be, my lord, if one time they can quote the figure, we can close.
The party is present before the court, and my party will.
I'm ready, my lord. I'll secure his presence.
Then file a memo, file an affidavit on that, we'll dispose it of.
In first they have to agree for payment, my lord, he's not paying
That's
anything.
Whatever you say that you both of you are ready to.
We will negotiate and close it, my lord. My lord, my endeavor.
My humble opinion. The party, both the parties present before the court.
How much is the amount with all these?
The
covered
present,
four
my
petitions?
lord, now present arrears would come to around 2,80,000 rupees.
These arrears of
No,
one maintenance.
That is arrears of maintenance. My lord, once and for all, if they were to quote a figure and they were to arrive,
The figure, inform me, tell him, and once both of you agree, then file a memo.
we can, my lord, she can
Ask
say
me,
for
get
divorce.
instructions from
I'll
your client.
consult my client and
Learn counsel for the petitioner submits that the parties are living separately from the last 25 years.
Yes.
25 years. Now the execution is filed seeking recovery of the amounts from
2013 onwards, my lord.
2013 onwards.
Sorry, 14, 15, 13, 14, 14, 15, 15, 16 and 16, 17.
17.
Yes.
Land council submits that as the parties are not staying together from the last 25 years, if the respondent is interested for the settlement, his client is ready to pay a lump sum amount. Then counsel the respondent submits that he'll get instructions in this regard. When?
next, after 10 days.
In the meantime, if you have instructions from the client, please inform him.
Definitely.
And by the
Definitely,
time the
I'll
matter
inform.
comes, you can come up with a joint memo before the court.
Definitely.
Yes, my lord. In
Yes.
fact, we can advance the MFA also and get it done, my lord.
The pose this matter on 26th.
Interim order is subsistent.
Interim order earlier granted is extended till then.
Obliged.
Cell number 8.
My lords, I appear for the petitioner in serial number 8. Kindly, my lord. 230, my lords. Grateful.
Cell number 9 for admission matters.
Well,
Rajeshwar PN.
I'm not keeping well today. I request day after tomorrow.
MFA of 2030.
Well, please, well, I require,
When it has come up, please look at the order.
Well,
honestly.
27/8.
Why it was adjourned on that day, give that.
well,
The last time I think I had taken it.
my Leonard has taken.
Sitting was
Last
not.
time he has asked, now you will ask.
No,
Well,
last time sitting was not there. man.
Well, only 2 days accommodation. Requesting.
For what advocates are not able to understand is now
But
you want.
I understand,
No,
well,
no, you want after 2 days. No, your case has to be accommodated in that. Already that list is running with 56 matters.
normally I could not, my lord, but today I could not. I'm sorry, my lord, I won't apologize.
Best of learn counsel the appellant for this matter in November 19th.
That's it, direct me to give a copy, government, copy is not served on it.
2013 matter, now the copy.
Copy is not served.
Counsel for the
I will
appellant,
serve.
copy of the
Please.
appeal memo on the council for
Please,
on,
I will take number and furnish, my lord. Today itself I will.
on the garment feeder.
LCR.
Yes, sir.
My lord, in the meanwhile, my office may have directed to secure the LCR.
The office is directed to, the registry is directed to call for the LCR.
My lord, A to abet is coming, my lord. It is, we have filed LR application that has been allowed. Wrongly it is reflected.
It will
in
be
the-
seen now.
Okay.
Cell number 10. E. Srinivas for appellant. E. Balakrishna Shastri.
Lord, I've challenged the order passed in miscellaneous petition seeking for restoration of the suit, which was dismissed.
What
my
is
lord.
the suit?
But
Suit for?
suit was originally filed for injunction, my lord.
Which
Thereafter,
year is the suit?
2004.
It's too early coming up for hearing before the court. 2004. When was it dismissed?
Dismissed on my lord, 9/11/2012, my lord.
9/7,
9/11.
9/11/2012. Then when the application is filed to set aside that order,
It was filed in the very same year. That is in the year.
not very same year, there must be, in a year there are 365 days.
10/12/2012.
10/12.
10/12/2012 miscellaneous petition.
10/12,
2012.
Miscellaneous was filed, my lord.
that is less than a month,
Please.
filed less than a month.
Within
1 month.
No, condoned petition is also not.
nothing.
Then,
My lord, what happens, my lord? Once the miscellaneous petition is filed, the statement of objections is filed on behalf of the respondent number 1. Thereafter, my lord, it was posted for inquiry. The petitioner was examined as PW1 and they were cross-examined by the other side also. Subsequently, what happened, my lord? The respondent also was examined. Unfortunately, for some reason, she could not be cross-examined. Court says that since the RW1 was not cross-examined, my lord, I am not entitled for restoration of the suit, my lord. That is the order passed.
we'll set aside this order and we'll restore the suit. Let it go on, how, on that ground, we can understand that if there is some delay.
My lords,
And we'll direct the trial court to dispose of the main suit, my main petition itself.
my lords, plaintiff's conduct may be seen, my lords. From the first date of hearing, they have not at all been attending the case, even in the High Court, my lords.
Let's see.
From
Please
From
tell
the-
me from when they are not issue emergent notice, 2 weeks time for furnishing PF. Appellant is absent, no representation, 4 tax time is granted as so and so. Appellant's counsel is absent in spite of sufficient time being given process so and so. Land counsel for the appellant is absent. There is no representation on behalf of appellant. There is no representation on behalf of appellant and respondent. Finally, you appeared on 2/2/2023, that right from 2018. At request of non-counsel, the appellant released it after 2 weeks. This matter is called twice and the counsel for the appellant is absent on 2 occasions, the counsel for the so and so. If it does not appear on the next day, the appeal will be dismissed for non-prosecution. And then some order is there.
Subsequently, it was dismissed and restored, my lord. By the
Restored.
What
Honorable
is this?
Court. By imposing cost.
No, not imposing cost. What is happening? Why are you not coming to the court? And why should the court accommodate you so many times?
There was some lapse, no doubt, my
It's
lord.
not some lapse. Some lapse will be on one occasion or on 2 occasions, not for years. Right from 18 to 22, you can't call it lapses.
No, after that, my lord, this court, considering my application, has allowed it imposed cost of 20,000 and restored the appeal, my lord.
Not 50,000, it's only 20,000.
20,000.
lords, even in trial court,
And
my lords,
thereafter, my lord, I'm, my lord, appearing.
trial courts also, they have not at all appeared, my lords.
We'll fix the time frame. Let it be taken to some logical and instead of on all these things. We'll say you should not issue, not even one adjournment shall be granted to him. He shall be disposed of within 6 months.
Seek instruction.
Because you can't seek instruction. That's going to be the order of the court. It's not a compromise or some consensus the court is seeking.
My lords,
Court is only telling you before passing an
my lords, the
order.
trial court, my lords, even in trial courts, they have not at all appeared, my lords. Even
No,
in miscellaneous
no.
petition.
If that's the ground, it is different. Now the first, yes, he was not appearing, the court has dismissed it for non-prosecution. Immediately within the limitation period, he filed an application.
Please.
Then just because the
Even in
respondent,
the miscellaneous petition, they have not appeared, my lords.
let's see the order,
Only-
come to the order.
Only chief examination they have.
Let's see the order.
In the reasons portion, page number 5, para number 9, perused the evidence placed on record by both parties. Admittedly, OS number so and so was filed by the petitioner in the year 2004. Exhibit P1 evident that the case was posted for plaintiff's evidence by imposing cost on so and so. The imposing cost by the court on 16/10/2010 would indicate that the petitioner was not diligent in prosecuting the case. According to respondent 1, the case was adjourned 8 times and the petitioner not chosen to lead the evidence. It is to be noted that the petitioner did not deny the contention taken by the first respondent. PW1 has stated in the cross-examination that she does not remember the date when the suit was posted for evidence. Looking to the cross-examination of PW1, the contention of the petitioner that the date of hearing was taken as
This is
1911.
suits for bare injunction.
It was for bare injunction, my lords. It was then converted for declaration and permanent. Court fee was not paid for 3 years, my lord. Once again, there also there is no diligence. Petitioner never appeared before the court to give evidence. This goes to show that the petitioner was diligent in prosecuting the case. The RW1 has specifically stated in his evidence that the petition is filed to harass the respondents and the petitioner has no interest in prosecuting the suit. To be noted that the evidence of RW1 remained unchallenged. The evidence of RW1 go to show that the petitioner has no bona fide in prosecuting the case. The suit is of the year 2004 and the petitioner, except in shooting the suit, did not come forward to go on with the matter. The petitioner, except giving evidence.
When the order is passed on 16th October 2015, why this is, when is this filed?
2016.
So from 2016 till 2023, it doesn't pursue this also.
Yes. No, that's not the case, my lord. Kindly see, on 7/8/2012, after the plaint was ordered to be.
No, I'm not talking about that.
Ah.
This MFI is filed in 2016. Till 2022, you have not appeared before the court.
Notice was issued, my lord. Thereafter,
No, several times you never appeared.
that, my lord,
That's right from 2016 till 2020. First time you appeared in 2022.
thereafter, my lord, the court, my lord, allowed my application, imposed cost of ₹20,000 and, my lord, relisted the matter for admission, my lord.
It is like, your suit is like a hanging sword. So you keep it live like this by paying costs
No,
again and
nothing
again.
like that, my lord. Your lordship, my lord, as, my lord, observed,
Before the trial court also, in a 2004 suit,
within,
till 2012, you have never cooperated with the trial court also.
no, my lord, that's not the case.
That's what is
On
recorded by the court.
no, court, my lord, relies on
No,
the,
you please, Mr. Counsel. You file the, all that docket proceedings, order sheets of the trial court. Yes. Then basing on that, we'll pass orders.
Even costs were imposed on each date of hearing. in the
That's
trial
right.
court.
We'll
They have
look at
not,
it. No, we'll look at it and by giving reasons, then we'll pass appropriate orders. Then counsel for the respondent shall place before this court the proceedings of the trial court, right from the date of institution from 2004 till the orders are passed. Yes, next.
Case number 11, M. Rajana Shetty for appellants, B.N. Jayadeva.
The defendant's appeal challenging the interim order of injunction granted by the trial.
Any order passed by this court?
My lord?
Any order passed by this court?
No, my lord.
No, then what is, no, why from 2025?
No, my
why
lord,
is the
because
injunction now?
notices are not served on the respondent.
No,
therefore-
that is true.
Yes.
No, after this much of the lapse of this time, when the suit must be at the fag end. And what, no, the purpose of asking for an injunction that time
No,
or a restraint order, whatever, both way, either ways, is one and the same.
No.
So what is the significance of it?
No, what my submission before my lord is, the court comes to a conclusion that my properties are different, plaintiff's properties are different. And granting an injunction, do the sustain. He has lodged a complaint to the police. He is a rowdy sheeter.
What is
The
the
what-
stage of the suit now?
The stage of the suit is at the stage of hearing the applications only.
Which year is the suit? Which year is the suit?
It is 2015. The ma-
Any stay in this? Any interim order? No interim order.
order. I will just pass on the document and also the event so that it will be easier for my lord to look at.
Give that in. Some date, whatever it is. What is the injunction?
The injunction restraining from interfering with the peaceful portion. Yeah.
So you are not interfering right from 2017 till now?
No, that's what they without interference. I have constructed my building in my property and I am residing
So
there.
this order is operating for 7 years, 7 long years.
7 long years, and they are taking the coercive steps that they sought for police protection
and the power of attorney word is a rowdy sheeter. It has been recognized by the Madibala police also. Then the appellant 1 and 2 are the doctors.
There is a respondent.
The restaurant been served, Miller.
Please, sir.
Advocate is
Then
also
Jayadeva.
appearing, I think.
David is filed.
Yes. We'll pass orders in the afternoon.
Much.
No representation. So, no. Pass over. Yes.
Cell number 12,
If you know him, please inform the council.
Yes, Miller.
Tripada,
Lord, respondents 1 and 2, Lord, filed a suit for partition. Lord, in respect of joint family properties as well as my self-acquired properties. Lord, I filed an application to vacate the injunction. Lord, that is rejected, therefore, Lord, I am before.
What is,
this court.
no, what happened to the suit?
Suit is, Lord, still in the stage of evidence of PW1, that is the,
Yes, let's see.
please. Just take, Lord, to. the-
Notices are served.
Sir remained absent, Lord.
Let's see.
May I take the, Lord, may kindly come to the reasonings at page number 14, Lord, point number 1.
Who are you? You're
And the second defendant, Lord, my father purchased the property in the year 95 by a sale deed. And then, my Lord, he gift the property in my favor on 6/6/2007. Lord, suit is filed in 2017 after 10 years challenging my gift deed and claiming partition, general partition. But my claim is only insofar as item number
If it
4.
is a
And
joint family property, then the father, how can he execute a gift?
it is
deed?
not the joint family property, my Lord.
That has to be decided by the trial.
Lord, it is not the joint family. It is
No.
purchased by a sale deed.
No.
I'll place the sale deed. That's what, my Lord, I.
That whether it is from the joint family proceeds or what, it is a matter of evidence.
Lord, nowhere in the plain they say that it is purchased out of joint family property. What they say is my father purchased the property. Nowhere they say it is the joint family.
For that, an evidence is required for court has to complete.
But still, Lord,
that.
after
What is
10
the
years,
injunction? What is the injunction? Not to
intention is
alienate.
not to alienate.
Then there is nothing wrong with that order.
And just take, my Lord, to the page number 15, Lord, in
Yes.
page 15.
Yes,
Lord, 7th line.
yes.
The plaintiff specifically contended that their father purchased item. This is important, Lord. Their father purchased item number 4, that is 114 measuring 4 acres through registered sale deed. But defendant number 2, by way of fraud, got
No,
executed.
all those issues will come in the trial, whether it is how it has been done, whether it is a.
Lord, it is
But-
not pleaded
but
by
it is-
them, Lord.
It is not
It-
your self-acquired property.
Lord, the property is gifted to me.
Gifted, that's what I'm saying. You're not, that is not your self-acquired property.
It is not my self-acquired property.
It is your
Lord, I
father's
was
property.
taking care of my father. He gifts my
They
property.
have sought a relief to that the gift deed is not binding on them.
Yes, they say.
All that have to be decided. Now, if you alienate the property unnecessarily, third party rights will occur.
Lord,
I can
mean-
understand if an injunction, something, some other order is, no, but as far as alienation is concerned, unless and until the suit is finalized, you can't alienate the property.
Lord, the court says that it might, Lord, I'll just take, my Lord, to
Please read.
the plaintiff specifically contended that their father purchased item number 4, a survey number 114, measuring 4 acres through registered sale deed dated 23/3/95. The defendant number 2, by way of fraud, got executed gift deed through the gift deed dated 6/6/2007. Lord, suit is filed in the year 2017. Plaintiffs pleaded they have share in the suit scheduled properties. Therefore, they sought for partition. My Lord, please come to the next page, page 16, my Lord. Last 10 days, 10 lines, my Lord. Though plaintiffs challenge the gift deed dated 6/6/2007, after the lapse of 10 years. the
Exactly,
plaintiffs-
that's what I said is the finding of the court. At page number, internal page number 7 of the order, middle.
Please,
Further, it revealed to note that, relevant to note that, the question that whether acquired property by father of plaintiff and defendant number 2 is a self-acquired property or it was purchased out of the income of the joint family property is to be decided.
please. Lord, this is the inference of the court, my Lord. It is not pleaded by the plaintiffs. Plaintiffs have never said in the plaint that it is purchased out of joint family.
Then plead that it's a joint family property, then it means that.
Lord, they must have at least one word. I would have understood, Lord, at least one word stating that it is purchased out of joint family income. Nothing is there.
Prime officer case is that's your father's property.
Father's property, my Lord, he gifts the property in the year 2007. Suit is filed after 10 years, knowing fully well that she is in possession. She has made huge,
No, the purpose of filing the suit itself will be frustrated if this order
Lord,
is not
other
granted.
properties, my lord, there are 6 items. Their share can be worked out in the other properties in the same survey number. I am just claiming only portion of the,
Provided if they are able to prove that out of the joint family proceeds, your father had purchased this property, then what will happen?
Lord, it is their case that my father purchased the property. Nowhere they say it is purchased out of joint family income.
Let's not be so technical. Please come.
Lord, at
Doesn't-
least a direction to dispose, my lord, 7
There
years
is a
old matter,
17,
7
yes.
years.
The agreed with the orders passed in I number 3. OS number 41 of 2017 dated 1st July 2022. The defendant number 2 is before this court. The respondents herein had filed a suit for partition and also a declaration that the gift deed dated
Lord, gift deed dated 6/6/2007.
6/6/2007 is not binding on the plaintiffs. It is the case of the plaintiff that the suit scheduled property is a joint family property. And as far as item number 4 and 5 of the plain scheduled property is concerned, that's purchased by the father and the defendant number 2 had fraudulently had got a gift deed in his favor. And according to them, it's a joint family property. Initially, the court had granted the injunction restraining the defendant not to alienate. And IA number 3 is filed by the defendant number 2 to vacate the order passed by the vacate the injunction order granted by the court. The court by order impugned had dismissed the said application. Learned counsel appearing for the appellant defendant number 2 submits that the property, it is never the case of the plaintiff that out of the joint family proceeds, the father had purchased this property. Even according to them, this property is purchased by the father by way of a registered sale deed dated 23/3/1995, which was gifted to the defendant number 2 in the year 2007. And the suit is filed in the year 2017. Learned counsel submits that in fact the said relief they sought is also barred by limitation. Further, the trial court had come to the conclusion that that the father might have purchased the property from the joint family proceeds. He submits that that is not the plea of the plaintiff himself, and there was no occasion for the court to give such a finding. And the trial court, beyond the pleadings, had granted the injunction restraining the defendant number 2 from alienating the property. He submits that he has been in possession of the property right from the year 2007 when the injunction was granted. It is submitted that the balance of convenience is more in favor of the defendant than in the favor of the plaintiff. It is submitted that the court below ought not to have passed, ought not to have dismissed, ought to have allowed I number 3 and ought to have vacated the interim order granted, injunction granted in favor of the, in favor of the plaintiff and against defendant number 2. Anything to be added? What about the respondents?
Lord, they are served and remained absent.
The next para, the respondents are served, but there is no wakalat is filed on their behalf. Next para, having heard the learned counsel for the appellant, peruse the entire material on record. The case of the plaintiffs that all the suit scheduled properties are joint family properties, and particularly suit schedule the property number 4 and 5 are purchased by their father, and fraudulently the defendant number 2 had got a gift deed in his favor, and they also sought a declaration to set aside to a declaration that the said gift deed is not binding on them. It is contended before this court that it is nobody's plea that it's a joint family property, and according to the plaintiffs also, it is purchased by their father in the year 1995, and he has gifted it in the year 2007. When he had purchased the property, that is his, he has every right to give the property. The argument of the learned counsel has no force and has no legs to stand for the reason It is assertion of the plaintiff and it's their pleading that the properties or the joint family properties and the father, the defendant fraudulently got got a say, a gift deed in his favor. When the contention of the counsel for the appellant is that there should have been a, unless and until there is a pleading that the property is purchased from the joint family proceeds, they are not entitled for such a relief. Even that contention has also no legs to stand. Looking at the case of the plaintiff, when they are pleading that it's all the properties or joint family properties. Now, by way of a full-fledged trial, unless and until it is decided that the property is purchased by the father independently, and the said gift deed that is executed in favor of the defendant is valid till such time if the defendant sells the property, alienates the property, and creates a third-party rights, the relief that is sought in the suit itself will be frustrated. Considering all these aspects, the trial court had rightly granted injunction restraining the defendant from alienating the property. In the considered opinion of this court, the trial court was perfect, the order passed by the trial court is perfectly legal and valid, and no grounds are made out seeking interference with the said order passed by the trial court. Next one. This is a suit of the year 2017. Considering the same, this court deems it appropriate to direct the trial court to dispose of the matter as expeditiously as possible, but not later than 1 year.
Right.
According-
Observations should not be, not
Any
any
of the
observations.
observations made by this court, that should be in the order, any of the observations made by this court. The trial court shall not be influenced by any of the observations made by this court while disposing of this application, and shall deal with the same independently on the merits of it.
Great.
Cell number 13, Sampath A for appellant, Saravana S.
This is a plaintiff's appeal, ma'am. That's
Notices
the
are
three
served?
matters.
Notices,
They've served, my lords, they're contesting. My lords, there are three appeals, my lords, because three applications were filed by me for injunction. Therefore, my lords, by common order, my lords, the application has been rejected. All applications are rejected.
you filed 3 applications.
Correct.
What is the suit for?
My lords, suit is for a declaration and other consequential relief. My lords, may kindly see, my lords, this MFA number 6031 of 2023.
Oh, there are 3 appeals.
Three
here.
appeals, my lords.
So
Now,
let's, 1 minute. MFA number 60, you should have given a synopsis, so that would have been easy
I'm
because
sorry,
there
my
are 3
lords.
matters.
I'm sorry, my lord.
So 6031 of 2023 is against?
Is against IA number 3.
What is that IA?
My lords, I had sought for a relief to restrain the defendants from preventing the plaintiff from entering and performing rituals or ceremonies in the temple. This is one application, my lords.
Defendants from,
Restraining the plaintiffs from performing rituals or ceremonies, my lords. Then, my lords, this IA number 2, my lords, was filed for restraining the defendants from demolishing the construction that was the structure situated in the temple. My lords, this is IA 2.
That is MFA 6042 of 23.
Sir, I think I'm competent to say, no? Yeah.
I'm helping you.
No, not required.
no,
Don't
it's
get
okay,
affected,
it's
sir.
okay. It's okay. Yes, next.
6049 of 2023
Yes.
is filed an application, my lords, for plaintiffs seeking an order of injunction not to obstruct the
It's IA number 4.
correct.
Hmm.
So all these applications, my lords,
IA number 4 is?
the IA number 4 is MFA 6049 of 2023 to restrain the defendants from interfering with the maintenance activities to be carried on by the plaintiff. My lords, now the suit scheduled property, my lords, is a temple. Now, suit scheduled property, my lords, is a temple. May I just request my lords to kindly take.
No, the temple, is it a public
No,
temple?
my lords, it's not a public temple, it's a private temple. Now, my lords, this property, my lords, purchased by the plaintiffs and that is the father of the plaintiffs, Ashwatthama, and his brother, my lords, jointly. There is a sale deed, my
There's a
lords.
relation between all
They
of
are
them.
brothers, they are brothers. My lords, may kindly take, my lords, the documents that I have filed on 19/9/2023, my lords.
In which case you have filed,
60 Yes, my lords.
Hmm.
Now, my lords, the document number one, what your lordship would say, I'm sorry, my lords, it's in the Kannada document, but it's a admitted document by them. My lords, on,
Property is purchased by your father.
by the husband and father of plaintiffs, Mr. Ashwatthama, along with defendant number one, who is the brother.
Husband and father means mother is the plaintiff.
Correct.
Hmm.
Mother is the plaintiff,
Hmm.
and along with her brother, defendant number.
Before we go to that, let's just look at the cost item. So that the court can understand the.
Yes, ma'am. My lords, that is first appellant, my lords, is a Maruti temple.
All this. Where is this 6031?
6031.
This is the one. Just please come to the cost item.
Cost title, page 5, my lords.
Hmm.
Now, my lords, first plaintiff or first appellant is Maruti temple, my lords.
Hmm.
It's a private family temple, I have stated that. Then, my lords, Lata Manjari is the wife of Ashwatthama.
No, who is this Chaitanya Kumar?
Chetan is the son of Ashwatthama.
Hmm.
Then Gayatri is the daughter of Ashwatthama.
You are all on one side.
Correct.
Hmm.
They are all, my lords, wife and children of Ashwatthama.
Hmm.
Defendant number one is the brother of Ashwatthama.
Hmm.
Then defendant number two is the wife of defendant number one.
Hmm.
Defendant number three, that is respondent number three, is the son of first respondent.
Is your brother,
Correct. Cousin, the first cousin.
cousin, or first defendant. Yes.
Correct. Therefore, my lords, Ashwatthama and first defendant are brothers.
Hmm.
Now, my lords, can we go back to the documents, my lords?
Yes.
My lords, now, the document number one, my lords would see at page 3 is a sale deed, my lords, dated 9/9/1968.
9/9/19.
68, my lords.
Hmm.
My lords, under this document, the Ashwatthama, who is the deceased husband of the first plaintiff, that is
When he
second.
died,
My lords, date of death, I will give, my lords.
1310.
2010.
Yes.
Now, my lords, he and the first defendant, they purchased this property on 9/9/1968.
Purchased together.
Correct. Jointly purchased.
Hmm.
No dispute, my lords, as regards this.
Hmm.
Now, my lords, may kindly go to page number 6. My lords, along with the suit schedule property, there were several other properties, my lords, belonging to the family.
Yes.
Now, my lords, they enter into a partition, my lords, is a registered partition, what your lordship sees
Hmm.
at page 6.
Hmm.
Now, that, my lords, is dated 30th of December 2002. Now, my lords, may kindly see, my lords, now, kindly take page number 15, my lords, running page number 15,
Hmm.
clause 6.
Yes.
My lords, whereas the parties, Hindu undivided family, have jointly purchased land measuring to an extent of 1 acre and 11 guntas in survey number 26/5 of Chikkamaranahhalli village, Kasaba Hobli, Bangalore North Taluk, out of their joint family funds, while it is registered sale deed dated so and so, dated 9/9/1965, it is stated, my lords, but it is 68. That is the document number one, my lords, what we saw. Then, in the office of so and so, for formation of RMVA second stage layout and remaining portion, some sites along with Maruti temple are in peaceful possession and enjoyment of the parties herein. Therefore, my lords, in the partition, they state that there is certain property 26/5 came to be purchased by them on 1968. Pursuant to that, there was some acquisition, some portion was left out, my lords. Now, in terms of this partition, my lords, the property that is the suit schedule property, which is a temple, was not partitioned. It did not come to be partitioned because it was decided that it is a temple property and therefore they will keep it as a
So
temple.
there is no whisper in this partition deed about the temple.
It is there, my lords. What I read was that clause 6 says, now, my
You
lords,
can read it, whereas the parties.
whereas the parties of Hindu undivided family have jointly purchased land measuring 1 acre and 11 guntas of survey number 26/5 of Chikkamaranahhalli village, Kasaba Hobli, Bangalore, North Taluk, out of their joint family funds, white sale deed dated so and so, registered in office so and so, whereas out of the full extent, some portion of the land was acquired by the BDA, Bangalore for formation of RMB second stage layout, and remaining portion, that is, some sites along with Maruti temple are in peaceful possession and enjoyment of the parties. Now, my lords, this is the covenants, my lords, that runs into the document. My lords, when your lordship sees the schedule, this property was not partitioned and it remained as a temple property. my
Except
lords.
at this clause number 6.
Correct.
You do not find any mention about this in the entire partition.
No, my lords. And my lords, we can also see the written statement. It is not disputed that under this document,
Please come to the property schedule.
my lords may kindly take, my lords, the plaint
No, I'm looking at page number 19.
19.
This is survey number.
Well, it's 26/5.
Hmm.
Well, it's this 26/5, my lords. In respect of the temple property, there is no partition, my lords. My lords, there are several properties, my lords, but my submission, my lords, is according to the pleadings of the parties, in terms of this partition, it is not partitioned, my lords. There is no dispute, my lords, as regards this. This is an admitted fact. My lords, may kindly go to now, my lords, page 26. My lords, this partition, there was a certain mistakes, my lords, in mentioning certain boundaries. Therefore, my lords, the rectification takes place on 22nd of November 2006.
Yes.
My lords, may kindly note, my lords, Ashwatthama was alive then. His wife, that is plaintiff number 2, his son plaintiff number 3, and Y.N. Srinivasa, who is defendant number 1 here, my lords, is a respondent number 1, were parties here. And another sister was also a party. Could my lords now kindly go to page 30, my lords? Clause 2. My lords, can I read from 6 lines from the bottom, my lords, where this, after the bold portion is there. Except this rectification, in change of the property bearing number so and so, A schedule, there is no other changes / rectifications, etc. in item number 1, 2, and 3, schedule properties of A schedule in the aforesaid partition deed. Whereas the Maruti temple property belongs to Ashwatthama and Srinivas, measuring by 54 feet by north and south zones. Now, my lords, again, my lords, a ratification that the property belongs to them. Now, my lords, because there was certain acquisition earlier, they have made it clear what is the extent of the temple property here. Now, my lords, we see the, my lords, it's about 54 feet by 90 feet is what, my lords, would be relevant. Then, my lords, what happens is, unfortunately, Ashwatthama dies. But just before that, my lords, we have some photographs just to see how the temple is, my lords, at page 42. My lords, we have got produced these photographs to show how the temple is, how it occupies, what are all available in the property, my lords, is what we see. Kindly now, my lords, go to page 46. My lords, page 46, your lordship is seeing a Kata certificate, my lords, dated 27/3/2018, my lords. Now, my lords, your lordship will find the names of both Ashwatthama and Srinivas, my lords, in the English portion down there, certified that the Kata of the property bearing so and so at so and so stands in the name of Ashwatthama Srinivas Y.N. in the register of Bangalore Mahanagar Palike, unique PAD number so and so.
That's 2018.
Yes, my lords. So it stands in both of this name. My learned friend was kind enough to give the date of death. We also presume, my lords, he died before that. But the Kata continued, my lords, because the property was jointly held by them. My lords will see, my lords, next page, my lords, is the mischief that they committed, my lords. What your lordship sees on the next page is that the Kannada portion where the name of Ashwatthama was available has been erased. My lords, on the 4th line, my lords, on the top.
It's a blank.
Correct. They have erased the name of Ashwatthama, who is the husband of second plaintiff, my lords. Why did they do this, my lords, is another very good reason.
It's for the main.
No, my lords, I'm sorry if I'm troubling with that. My lords, there is certain very important aspects why I'm showing this document. Now, my lords, we throughout now saw that this property, my lords, temple property belonged to Ashwatthama and Srinivas. Now, my lords, now they manipulate the kata, and my lords, there is a gift deed that is executed by Srinivas in respect of his very same property. Sale deeds are executed by him pursuant to the death of Ashwatthama, claiming that there is a oral partition. my lords. Now, this is the entire defense that they have taken in this case. Now, kindly see, my lords, page 50.
What sale leads in respect of a temple?
Kindly see page 50, my lords. We will understand, my lords, what is the sale deed they did. My lords, 31st of March 2018, it appears, my lords, he creates a trust known as SMS Trust. Respondent number 1, YN Srinivasa, my lords, he claims to be the trustee. His wife is Suraksha, that is defendant number 2, and his son is defendant number 3. Now, my lords, kindly see, my lords, the purchaser of this property is the wife of respondent number 1, Suraksha, who is also a trustee. What is that they are selling? Kindly go to page 61.
No, Suraksha is also shown as party number.
Correct. She claims to be the trustee, and she is the purchaser of the trust property also. And now, my lords, they say that the very same temple property has been endowed to a trust, and that property, my lords, they have sold it. All these happens, my lords, after the death of Ashwatthama. After manipulating the kata, they go and register these kind of sale deeds. What is that they sell, my lords? May kindly see the schedule at page 61, my lords. Now, my lords, they sell about 30 feet by 50, 30 feet by 50 feet. My lords will kindly take page 53, which is a sketch annexed to the sale deed, because, my lords, it's very clear.
50?
63, my lords, 63.
Hmm.
Site number 2, my lords, finds on the top. This portion of the temple, they sell it to defendant number 2. This portion of the temple, where your lordship sees sites number 2, measuring 30 feet by 50 feet, is sold in favor of defendant.
His wife. Defendant number 1's wife.
Correct. Then, my lords, may kindly see, my lords, there's one more, next document is 65. Now, my lords, they claimed that there was a trust. Now, because they wanted to alienate all these properties or take control of this, they also cancelled the trust deed, my lords, that is at page 65. Now, my lords, Srinivasa, my lords, who is defendant number 1, respondent number 1 here, claims, my lords, that he is a settler of this property. Then, my lords, his wife and children are again the other trustees. Kindly go to page 69, my lords. Is a schedule, my lords, all that piece and parcel of property bearing BBMP number so and so, portion of property bearing number 26/5, situated at so and so, measuring east to west 52 feet and north to south 90 feet. Now, my lords, this is the very same property, my lords, is suicidal property. Therefore, what is the mischief does not end here. Kindly see page 72. On 4th of May 2018, not satisfied with site number 2 being made in the name of a wife, my lords, Srinivasa, defendant number 1, executes a gift deed, my lords, in favor of Suraksha, his wife. My lords, may kindly go to page 82, my lords.
Very same property gift deed.
No, my lords, very same portions. What they do, my lords, is that we saw site number 2, they marked it saying that it is 30 by 50 feet. I'm giving it under a sale deed. She purchases it for about 30 lakhs. That's what the document says. Now, my lords, they wanted to show another portion also they wanted to convey. He executes a gift deed, my lords, at page 82. The site number 1 has been numbered here. And he sells this portion. I mean, gifts.
The gift deed is in favor of whom? Son, na?
Daughter, wife, Suraksha.
Suraksha only.
Yes.
Oh, so now site number 1, site number 2 are given to Suraksha.
Correct.
Prayer hall is given to son.
Correct. And this is again given to another son. This prayer hall as well as prayer hall 1 and 2, my lords, what your lordship sees 18 by 40 and so on. Therefore, my lords, like in this manner, the entire temple property, my lords, your lordship sees the sketch. Temple identification itself is not there. In this manner, my lords, the entire property, my lords, has been conveyed in favor of
Now
the
please
defendant.
come to the. Then now what you sought, let's see your plaint. Then
My
you
lords, may I
directed
kindly put-
all this before the court.
Yes, I have placed. My lords, prayer in the suit, my lords, finds at page 30.
You wanted page 30.
Yes, my lord. Judgment and decree declined the gift deed dated so and so as fraudulent and not binding on the plaintiff. My lords, next prayer, my lords, is with regard to another gift deed. So all these gift deeds, my lords, whatever was executed, I've said it's not binding on us. Then 3, consequently, to issue necessary direction to the senior sub-registrar, so and so Bangalore to cancel the registration of the said 2 gift deeds. Then perpetual injunction, then restraining the defendant from causing any obstruction or objections for ingress and egress into the suit schedule property by the plaintiff from obstructing against the plaintiff's performing
I've
any.
seen. Now please come to the reliefs in the IA. Which
My
page
lords,
is it?
Page 43, my lords. Forty-four is the relevant portion. My lords. That for the reasons warranted in the accompanying affidavit, the plaintiffs pray that this honorable court may be pleased to pass an order of temporary injunction restraining the defendants, their men, their agents, their servants from
This
obstructing.
relief is IA number 3.
Yes, my lords.
That's only to cut short, my lords. IA number 2 and 3, we have given undertaking before the court that we will not restrain her. She later perform the puja, whatever it is.
What is it?
Therefore, my
IA
lord,
number?
2 and 3,
Hmm.
we have stated, we have given undertaking and even stated no objection. For IA number 2 and 3, what falls for consideration is probably IA number 4.
So let me look at the
IA number
prayers.
4.
Prayers. 44 is IA number 3.
Yes, my lords. 44.
IA number 2 is where?
My lords, that is in the other
6042. The
Hmm.
MFA appeal 6042.
Page number?
604. Page number
46,
46, my lords.
46.
Hmm. Then IA number 4 is, in which case that we will take first.
Yes, 6049.
6049,
We'll
page
take
44. my lords.
6049 first.
Marriage, page 45.
One. So in spite of that, why did you file question it when they have filed an undertaking?
No, my lords, that is my lords pursuant to that. My lords, to be honest, my lords, if we take your lordship to the objections to the applications, such an undertaking is not there, my lords. But my lords, in respect of IA number 2, my lords, they did say, we will not demolish. They did say that, my lords, that they will not demolish as regards IA number 2 was concerned, because IA 2 was, my lords, not to demolish any portion of the structures.
So then why again you have questioned it?
My lords, because they were in spite of it doing. My lords, what happens, my lords, it was,
So if they are, one minute,
I will
if they
file
are doing
affidavit.
it.
there was no
then-
order, my lords. There was no order.
Then we will record.
Lords,
his
I have no
submission.
problem as regards
IA
second.
number 2 and 3, he says that we have given an undertaking that will be recorded.
Yes.
Now let's come to IA number 4. Let me just see in IA number 4, where is the prayer, that IA
40
prayer,
45 minutes.
45.
May I read, my lords?
Temporary injunction restraining the defendants.
From causing or obstructing or objection to the plaintiffs 2 to 4, from maintaining the temple and its
No,
properties.
even according to you, it's a joint property. No, in that case, why there be the injunction against another owner?
No, my lords. That is, my lords, I would restrict this player, my lords, that let there be a permission, even suppose, my lords, suppose I want to do certain betterments. Can they restrain me, my lords? My lords,
No, because a dispute is pending with regard to all this. Let both of you don't do anything. Let it
that
be
cannot be, my
maintained.
lords. What happens? It's a temple, my lords.
Uh,
My lords, periodical pujas needs to be done.
Just you do.
No,
like
no, my lords,
whatever
what I meant
normally
is-
What has to be done?
My
both
lords,
of you
suppose
can
some
do it.
whitewashing needs to be done, some betterments need to be done. My lords, I would have no
whenever
objection,
you
my
want
lords.
to Take the permission of the court. No, neither you nor him, now the court at this stage cannot say that you are permitted to do or he is permitted to do.
My lords, I would definitely bow down, my lords, because the suggestion seems to be, of course, my lords, in the interest of the temple. My lords, if such an observation is made, my lords, to dispose of, in the eventuality, my lords, we need to do some betterments. Let us assume, my lords, I need to do a whitewashing. Let us assume something is falling off, something is.
So how it is running now?
My lords, I do not have any grouse, my lords, that the temple is in fact, my lords, if pujas are being performed and all those things.
Hmm.
I do not have any complaints as regards.
No, now we'll dispose of this IA number 4, IA number 4, right?
Yes, my lords,
IA number 4. IA number 4, whenever you say that any, in the betterment of the temple, something has to be done, then let an application be moved before the court.
No, that can't be the order because
Hmm.
I have serious objections because from 1994, for almost 25 years, I have installed the deities. I have been conducting the management of the temple since from 1994. From past 25 years, I have been managing the property.
What is placed before the court to
Lords,
come to such?
Lords, kindly see, Lords, kindly see.
Let's come to the order. What is that the court has understood?
Lord, court said there is no pleading in the plaint as on the date of filing of the suit, he was under the management. And second thing is the main relief at page number 31, Lordship will see, prayer number 5. The very main relief is sought. Therefore, court said at this stage, it's amounting to granting of main relief that I will not do.
Let's see that. Let's see
Please.
what is the, how the court has considered.
Millets, page 24, Millets.
Please read-
Can we,
please read
Millets,
from
read from
14.
13, Millets?
Ah.
That is paragraph 13 on page 23. On perusal of the pleadings, it is undisputed fact that the property bearing survey number so and so was purchased in the joint names of Ashwatthama and the first defendant under the sale deed dated 9/9/1968. But the contention of the defendant is it was purchased by first defendant from his income that the said L. Ashwatthama was not doing anything and his expenditures has been undertaken by the first defendant after demise of L. Narayan Swami, which needs a full-fledged trial to conclude on questions of so and so. Now, my lords, kindly, I'm sorry to pause here, my lords. Now, no document whatsoever, my lords, was placed by them to show, my lords, that it is only them that were doing the functions, my lords. They have not.
The plaint, have you stated so that I've been actively
Of course,
involved and I'm doing?
I have, my lords, I have.
Let's
I have
see your
stated.
plaint.
The page 27.
28, my lords.
Please point out that particular para.
My lords, paragraph 5, can I read, my lords? The temple existing in survey number so and so was renovated by both Ashwatthama and Srinivasa by enclosing the precincts of the temple in area measuring about 5,000 square feet. Vimana Gopura Dvajaswamba was installed somewhere during 1994 and was thrown open to the public. Aralikete, Naga, whatever, there's some seal is there, my lords, Mantapa, two storehouses and a house for the architect were also constructed within the scheduled property. The property where the temple stood was therefore dedicated to the temple, and the ideal, who is plaintiff number 1 and defendant number 1, plaintiffs having relinquished their right, title and interest over the scheduled property in favor of plaintiff number 1. The property is subject to the suit of this sort and is more fully so and so. Unfortunately, that the date of death is there, my lords. Well, it's paragraph 8. As on the date of the suit, the temple does exist on the suit property, and it is a temple which is in possession of this suit property. The plaintiffs are presented the suit as Dharmadhikari of the temple.
No, he has not stated anything about when you are the one who is seeking injunction.
Correct, ma'am. My lords, I have stated in my affidavit, my lords, running along with the application, my lords.
Where is that?
46, my lords. Paragraph 3, my lord. Affidavit, my
The
lord.
relief as framed by you itself is not maintainable. The relief has sought, saying that somebody is a joint owner of the property.
My lords, I
And
do
you say
understand.
that you restrain them from.
No, my lords, and my lords,
There can't be an injunction against the true
my
owner.
lords, it is
You
not.
should have been very careful in seeking the relief
No,
itself.
my lords,
And
I just
relief-
read
and
the
relief
relief.
is I am restraining it. That means he is admitting that I am managing.
No, I'm definitely, I'm saying he's restraining. My lords, just, can I read the prayer, my lords, in the IA? Restraining the defendant, their agent and so on so from obstructing or causing obstruction or objections to plaintiffs 2 and 4 from maintaining the temple and its properties.
So
And-
for seeking such a relief, you should show that you are maintaining the temple.
Correct, my lords. I have stated, my lords, in the affidavit.
Not
that-
about the alone stating, because they have on affidavit, you will also say that you are not managing.
My lords, therefore, my lords, I said, my lords, the concession, my lords, my lordship said that in the eventuality, my lords, I need to do something. Why should I be prevented from carrying on benefits to the temple, my lords?
No,
I
once you
don't-
succeed in
No, no, my lords,
establishing.
success is one thing. Well, it's
No,
not,
prima facie, that's where the prima facie, no.
well, it's
what he
prima
says-
facie, my lords.
No, if it is both of you are agreeing, that's a different aspect. No, when when he disputes that you're not at all managing the, property may be belonging to both of you. But who is managing at this point of time, you need injunction or not is the issue. You are saying that you are managing, he is denying it. In that case, there should be more than saying on affidavit, there should be something more than that.
Well, it's a voluntary statement this man is making, that the plaintiffs want to maintain the betterments of the temple, my lords. I do not understand why they are trying to say you don't do any
No,
betterments.
what are your great intentions?
Because I am
The
the
court do
temp-
not know.
No, no, no.
You
No,
should
no, no.
say,
Therefore, my lords,
that, something to be there.
No, my
Your
lords,
assertion
therefore-
may not be taken into consideration.
therefore, my lords, in fact, suggested, in the eventuality of certain benefits that I want to do it, I will place on record, my lords.
No, not you want to do. Now, according to him, he is managing. And if something he is not doing in the interest of the
Let's,
temple,
with,
bring it to the notice of the court.
let's with this observation, it could be.
Bring it to the notice of the court that some of the actions
If
of
there is
this
any
respondent are
mismanagement-
detrimental to the.
Mismanagement or anything.
Mismanagement or not conducting proper administration.
If you are
properly.
not
Yes.
taking, is not, the affairs of the temple are not conducted properly,
Please, my lord.
which is not in the interest of the temple, bring it to the notice of the
Yes.
court.
But with this observation, I think, my lords. And I think we have no gross, my lords, with regard to the other two appeals.
Yes, that I'll record.
But
It's already fairly submitted. to the
Not to,
council,
not
they've
to,
already
not to
issued.
demolish or,
But in fact, we filed affidavit before the trial court. I didn't have the copy.
One
What may
affidavit,
record
my
my
lord?
statement.
I'll record.
one affidavit, my lords, as regards second appeal, they have done, my lords.
No, when we submitting will record,
Yes, my submissions may be before. I number,
agreed with the orders passed in. IA number,
2, 3, 4.
IA number 2, 3, and 4. Dated,
My lords, all applications are filed along with the suit.
no, not applications dated. I'm
Order-
asking
orders.
about the order is one
Order.
and the same.
My lords, 24th of July, 2020,
21st of July,
23.
21st of July, 2023. The plaintiff is before this court. The plaintiff had filed a suit seeking the following reliefs. Page number 30 in WP number, in MFA number 6049. The reliefs are at page number 30.
31.
31. Extract the reliefs, file the suit seeking the following reliefs.
13, my lord.
In that, he had filed I number 2, 3, and 4. The relief that is sought in IA number 3 is, that is in IA number 3, that is MFA number 6031 of 2023. At page number 44 is the prayer. Extract the prayer.
Could it be said
Then
IF4,
in
my
IA
lords?
number 2, MFA number 6042, the prayer is at 46. Extract that prayer. Then IA number 4, the prayer that is sought is page number
45, my lords.
44 and 45.
40?
5.
5.
That's at 45 in MFA number 6049. The agreed by the orders, the 3 MFAs are agreed by the orders passed by the trial court. The 3 MFAs are filed. They are MFA number, same numbers, MFA number 6031, MFA number 6042, MFA number 6049 of 2023. As all these IAs are arising out of the same suit. And they have been disposed of by a common judgment. It's a common judgment?
It's common order.
Common
document by common.
by a common order. This court is also disposing of all these appeals by way of a common order. When the relief, as far as IA number 2 and 3 are concerned, land counsel appearing for the respondent submits that they have already filed an undertaking before the trial court that they will not do any of the acts as sought by the plaintiff. And in view of that, no adjudication is required on IA number 2 and 3. Considering the same, considering the undertaking given by the defendant respondent before the trial court, trial court, and
And
as
also
they've already undertaken.
Sorry, my lords, and also reiterated here.
Huh?
And also reiterated because my learned friend is saying that IA 2 and 3 he had submitted. But my knowledge says, my lords, as regards IA 2, only it was stated before the trial court.
We'll record
Record
this.
as a submission
Therefore,
is my submission that I
The
will.
Land Council submits that IA number 2 and 3. They've given an undertaking in that view of the matter. No adjudication, no orders needs to be passed in this, and in the light of the same, the respondent shall not do are restrained from doing any of the activities as sought for in IA number 2 and 3. Then coming to IA number 4, the plaintiff is seeking an injunction restraining the defendant, the defendants from obstructing or causing any obstruction or objection to the plaintiff's 2 to 4 from maintaining the temple and its properties, and meet all requirements of maintenance, upkeep of the temple, and for this purpose, unrestrictively to enter and exit the scheduled property so as to meet the ends of justice and equity. It is a case of the plaintiff that the property, the suit scheduled property where the temple is situated is purchased by her husband and defendant number 1 jointly by way of a registered sale deed dated 9/9/1968. In between the parties, a partition deed was executed on 13/12/2002. Even as per the said partition deed also, they have not, though it is mentioned about, though in the said partition deed, they mention about this property where the temple is situated, but in that also, there was no partition and it was in joint possession of the property. Thereafter, on 22/11/2006, a rectification deed is executed. Even in the said rectification deed also, the temple property remains to be in a joint possession of the parties. It is stated that the husband of the plaintiff died on 30/10/2010. Even as on even as on 27/3/2018,
Yes, my lords, the Kata. my
even
lords.
on 27/3/2018, the Kata stands in the name of the husband of the plaintiff and the defendant. Land Council has pointed out, it is, no, there is a document file which shows that in the very same document, in another Kata, the name of the plaintiff's husband do not find place. According to him, according to the plaintiff, thereafter, 4 gift deeds, or thereafter, the property by way of sale deed or by way of a gift deed was given by the defendant to his wife and to the 2 sons,
One son.
to the son.
2 and 3, lordship may say defend number 2 and.
Defendant number 2 and 3. Now the suit is filed seeking a cancellation of all these gift deeds and also a declaration. It is a case of the plaintiff that he has been managing they have been managing the temple, and now they seek an injunction restraining the defendant from interfering with the same. When an injunction is sought, it is the burden lies on the plaintiff to show that as on the filing of the suit, he has been managing the affairs of the plaintiff. Except stating so in the affidavit in support of the IA and in the plaint, no other evidence is adduced before the trial court.
Lordship may say document because it is, no, it's not posted.
No other document is filed before
Notice,
the
permit.
court. Land Council for the respondent submits that they have been, the defendants are managing the property from a very long time. No doubt, they also have not filed any documents in support of their case. Basing on the weakness of the defendant's case, there can't be an injunction in favor of the plaintiff. And basing on the documents or basing on his evidence, the court has to consider the injunction application. Considering all these aspects, the court had rightly not granted injunction in favor of the plaintiff, restraining the defendant from doing any acts as sought for in I number 4. Learned counsel and expert. Learned counsel appearing for the appellant submits that there is as far as the joint that the plaintiff's husband and the defendants are the joint owners of the property. By filing the documents before the court, the plaintiff could prima facie establish the same. It's according to the counsel, it's his prima facie case. Now, if the defendant is meddling with the property and doing the acts which are not in the interest of the temple and the devotees who are visiting the temple, the plaintiff cannot, he cannot be made to, he can't be a mute spectator to that. And he has every right from injecting the respondent or defendant from doing any of the acts which are not in the interest of the temple. As far as this aspect, the submission of the land counsel for the appellant is concerned, this court finds that there is a force in this argument. If in that view of the matter, this court feels that there shall be this MFA can be disposed of, giving a direction, giving liberty to the plaintiff to bring to the notice of the court whenever any act of the defendant is not in the interest of the temple and to the detrimental to the interest of the temple, if he is taking up any activity, it shall be brought to the notice of the trial court by making an appropriate application, and the trial court shall consider the same on the merits of the matter. Accordingly, the MFA is disposed of in the following manner. 1, as far as IN number 3 and 4 are concerned, 2 and 3 are concerned, that is MFA number
6042 and 6031.
6031 of 2023 and MFA number 6042 of 2023 are disposed of in the light of the undertaking given by the defendant before the trial court and the submission of the counsel for the respondent before this court, that they will not do any of the acts as stated by the
Not record mine. That's because if they case notes, I should not be.
As per the undertaking given by the defendants before the trial court, the respondent, what is that? So and so is disposed of in the light of the undertaking given by the defendants before the trial court, that they will not be doing any of the acts as per the relief sought in IA number 2 and 3. 2 and 3. IA number 4, that is WP number, MFA number
49 of
6049 of 2023 is disposed of, giving liberty to the appellant to, same, whatever I've said up, same paste here, accordingly disposed of.
The cause list shows, my lords, respondents 2 and 3 are not,
Lordship may show my.
All the respondents,
They represent.
it is submitted by the land counsel that for all the respondents, he is apparent. Yes.
I live blessed.
Serial number 16, Badrinath Raj, appellant. KP Bhuvan,
I pay for the appellant. Parties have agreed for the settlement.
Memo is filed.
We agreed for the 20. we
The
agreed for the 20
appellant is the plaintiff in the suit or the defendant.
Defendant in this, defendant.
Appellant and respondents of the appellant has agreed to pay a total sum of rupees 24 lakhs to the respondent, that is the plaintiff, as full and final settlement in respect to the registered sale agreement deed dated 25/7/2015 in respect of the suit scheduled property on or before so and so, and the respondent has agreed for the same. Agreed to pay now some of these favors by way of post-dated check bearing number dated drawn at Federal Bank so and so. Post-dated check is 10/1/2025.
Yes. So another one is
And the one is 25/11/2024.
and one is 10/1/25.
If the appellant committed any default in first installment amount and the appellant undertakes to pay an additional amount of 50,000. And so, penalty through the process of respondent is acknowledgeable such amount. It's already received. The checks are received. Then you will file an appropriate memo before the trial court.
Trial file. Let the matter be before the trial pending before till
Till
15/1/2025.
that post-dated.
Checks are
Will
clear.
give a direction that this matter shall be listed before the trial court on in the month of
16th or 17th.
10/1/2025 is the date. So let this be listed on in the month of February. Because
By
any.
20th, it can be posted. By the time I'll be clear. 15/1/2025 will be clear.
20th, that is 21/2025.
Yes, ma'am. And regarding the court fee, my lord, I paid 1,12,000 in the court below. In view of arriving the compromise, I can entitle.
That's all you can say before.
Reservation, no, because in
The-
miscellaneous, yes, no, my lord.
This is a miscellaneous petition which
Miscellaneous
my
petition,
petition came to be dismissed.
So already a suit came to be decreed. So if this honorable court observed that,
Yes. The present MFA is filed. Agreed with the orders passed in miscellaneous number 04 of 2021 dated 12th September 2023, whereby the court had dismissed the petition with costs of rupees 2,000 to be paid to the respondent in the execution number 09 of 2019. Then I number 1 filed with the petition under section 5 of the Limitation Act is also dismissed. The OS number 72 of 2017 is filed seeking specific performance of an agreement of sale dated
25/7/2015.
25/7/2015. The court had passed an ex parte judgment and decree on 20/12/2018. Thereafter, the present miscellaneous application is filed to condone the delay of
Delay of 18 months.
18
months.
18 months. To condone the delay of 18 months and to set aside the ex parte judgment and decree dated 2012/2015. The trial court had dismissed the said application. And while dismissing the application, the court observed that the order sheet of OS number 72 of 2017 shows that the respondent had taken the summons through court RPAD and also through a fixture. The careful perusal of the shara made on the summons shows that the villagers have informed the process server the defendant was not residing in the said address at present, but the very admission made by the petitioner, the defendant in the cross-examination, that his family members are still residing in the village shows that he has got a link with his relatives at the village. Even as per the deposition of PW1, he had relinquished the said property to his uncle's son. The said transaction was not a sale transaction on such circumstances. the court has come to the conclusion that the defendant is aware of the the pending proceedings. And the court find that there are no reasons to set aside the judgment and decree passed in OS number 72 of 2017. Against that, the present MFA is filed. When this MFA has come up before this court, on 30/8/2024, it is submitted that there is a scope for compromise and sought for time. And accordingly, the matter was adjourned. On 5/9/2024, when the matter came up before the court, it is submitted that the parties have compromised and they will file a memo before this court. Today, the parties have filed a compromise memo before this court. Both the parties are present before the court. The compromise reads as follows. From page 4 to page 6 of the compromise, extract all that.
Para 6 also.
Hmm?
Para 6 of page number 3.
Page number?
Page number 3, para 6. Total final settlement is.
Page from para number 6 to end of the compromise. And as per, after that, as per this compromise, the appellant had agreed to pay a total sum of rupees 24 lakhs as a full and final settlement. For that, he had given a check for 12 lakhs, a post-dated check dated 25/11/2024, another check for 12 lakhs, which is dated 10/1/2025. And in case there is any default in the first installment, the appellant has undertaken to pay an additional amount of rupees 50,000 on or before 15/1/2025. And basing on this compromise, they will, and after they will report the court below. And accordingly, they will place all this before the court. Land counsel appearing for this respondent submits that he has already paid a court fees of rupees
1,12,000.
1,12,000, and as this matter is compromised, he is entitled for return of the said court fees. Parties, the parties who are present before the court submits that the appellant today had given the two checks for the amount of post-dated checks for an amount of rupees 24 lakhs to the party to the party respondent who is present before this court. Considering all these, this compromise, the joint compromise, the compromise before filed before this court is taken on file. And in the terms of the compromise, the MFA is disposed of. The trial court shall take up this matter on 20th of Jan 2025. And the parties shall be taken up to report the conclusion of the compromise. This joint memo shall form part of the order, and the same shall be annexed to the order.
My lord, I deposit 17,50,000. I'm entitled to receive that amount in the court. So written.
What, that is not stated in this?
Mentioned.
No, even in the compromise, it is mentioned that the plaintiff had,
Para 4,
plaintiff had deposited an amount of rupees
17,50,000.
17 lakhs 15 or 50?
50.
50,000. In the light of the compromise, he is at liberty to withdraw the amount. And the parties, their Aadhaar cards and they have their identity and ask her to look at it.
Case number 17, Deepak Bhaskar.
Is your Ladyship. This is the defendant's appeal. I am the fourth defendant in the underlying suit.
17?
Please,
Yes.
fourth defendant in the underlying suit. My ladyship gets the rank of,
The notices are served on the
yes,
response.
yes, yes.
Nobody is appearing.
No one.
Manjunath,
In fact, that is one of the
Counsel Manjunath.
Oh, his name is before the trial court.
trial court, yes. In fact, the plaintiffs, my lord, they don't furnish their addresses in the suit. Yeah, I'll point that out. This is, your ladyship,
What is the suit for?
the suit is for declaration and partition.
Declaration and partition.
And partition.
Hmm.
What is challenged before your ladyship is a common order passed on the plaintiff's application for injunction under 39(1)(2) and my application for vacation of that injunction under 39(4). The plaintiff's case is that they are related to my vendors. Interestingly, on 18/10/1988,
You're a third party.
I'm a third party. I'm a subsequent purchaser.
This declaration is to such a, that sale deed is not binding.
That's right.
When is the sale deed?
1988, 18/10/1988.
1810?
18/10/1988
Hmm.
is the sale deed that is entered into, executed in favor of my vendors, who are the defendants 1 to
Did you
1.
purchase?
I purchased on 15/11/1991.
1511 19?
1991.
1991. No, how many are the defendants?
There are 4 defendants.
Who are the family members?
There are no family members. That is what was urged before the trial court. Interestingly, there are 2
Then
points.
what is this suit for partition?
The plaintiff urges that my vendors purchased the suit scheduled property out of joint family funds. Absolutely no shred of evidence to substantiate that point.
You purchased from whom?
I purchased from their purported siblings.
No, no. Who has sold the property to
Please.
your vendor is not a party
Defendant
to the
1
suit.
and 2. No, my vendors are parties to the suit. The
No, no, your
plaintiffs,
vendor should be the party, his family member.
that's right. So the plaintiffs claim to be my vendor's siblings. They say that this vendor has purchased the suit scheduled property out of joint family funds, subsequently sold it in my favor, and has suppressed the transaction to them. Therefore, 32 years later, they have now found out, and they come to,
Oh, something is missing here. Please come. to the point.
if your ladyship will just come to page 7, the rank of the
Huh.
parties,
Let's look at it faster.
please.
Hmm.
Your ladyship will see respondents 1, 2, 3,
Hmm.
Ramnath Iyer, Varadraj Iyer, Sangeeta Iyer. These are the plaintiffs.
Yes.
These plaintiffs claim to be the siblings of respondents 4 and 5, that is Krishna Iyer and Sita Lakshmi.
Hmm.
4 and 5 are my vendors.
That's what I'm asking.
That's right.
Hmm.
So 4 and 5 are my vendors. They purchased in 1988. They sell to me in 1991.
They purchased from whom?
They were employees of Motor Industrial
They purchased
Corporation
the
Organization. Private property.
Hmm.
So there's
So
absolutely,
now they say that it's a joint family.
they say it is joint family property.
Hmm.
They say it was purchased from joint family
And what
funds.
is their case that how did they come to know about the sale deeds of 1998?
They say that we had returned to our native place. One fine day, we come to the property. Our neighbors tell us that there's a transaction. We go to the sub-registrar's office. We find out there's a third-party transaction. Therefore, we filed the present suit. Two contentions were raised before the trial court. One was on limitation. We say doctrine of constructive notice squarely applies. Section 3 of the Transfer of Property Act is clear on this. Secondly, and this is the more pressing point, in the family tree that the plaintiffs produced before the trial court, there is no link between my vendors and the plaintiffs. If your ladyship will just take a look at that family tree, which is at page 67.
Simply they mention that all are son of late K.K. Anantara.
They say that, but please see the family tree at page 67.
Hmm.
Only the plaintiffs' names are mentioned.
67.
Yes.
Hmm.
These are the respondents 1, 2, 3 in the present appeal, who are the plaintiffs in the underlying suit. Now, in our 39(4), we point this.
They are seeking partition at the age of 82 years.
That's right. No, what is more disturbing, your ladyship will see, is we pointed out in our 39(4) that there is no prima facie case because forget joint family funds, there is no joint family relationship by this family tree. What happens is at the time of arguments, a new family tree is produced with a memo of citations. The learned trial court relies on that
Where
memo
is
of
that?
citation. Please see at page 181.
If your ladyship will please see 179 first. Written in hand at the very bottom at 179. Fresh family tree of so and so already produced. Please see 181. 181 now is a new family tree to overcome the very objection that I've raised by 39.4.
No, there are two vendors.
That's right.
That is Krishna Iyer and Sita Lakshmi.
Krishna Iyer and Sangeeta. Sorry, not Sangeeta.
Sita
Sita Lakshmi, husband and wife.
Let's see. Oh, they are husband and wife.
Husband and wife.
So where is no Krishna Iyer is shown as one.
That's right.
One
Whereas
is-
in the previous family tree, no mention is made. In fact,
Like from what are they? What is the? Let's go to the plane.
please,
Which page number?
the plaint is at page 51. If your ladyship will see paragraph 2, they say plaintiffs submit that the plaintiffs and the first defendant are full blood brothers born to so and so. The second defendant is the wife of the first defendant and sister-in-law of the plaintiffs. Defendant number 3 is the alleged purchaser, and the fourth defendant is the wife of the third defendant. For better clarification, plaintiffs are producing the notarized family tree marked as document number 1, which is the first family tree your ladyship has seen. At paragraph 5, they say it is further submitted that the first defendant being the employee of Myco Factory and the society allotted membership to the first defendant by said society in membership so-and-so. Thereafter, said society came forward to allot a site in favor of the first defendant, formed in the above said survey numbers. Accordingly, said site number so-and-so was allotted by the said society, paid sale consideration of 34,500. At that juncture, the first defendant did not have money for purchasing the said site. Therefore, he requested all the plaintiffs to generate funds to purchase the said site. At the time, the plaintiffs have also arranged funds along with the first defendant. This is the sum and substance of his claim.
No, come to page 54.
Please.
54, bottom, about
Yes.
5 lines. Please read that. The said amount.
The said
is-
amount was paid on 3/10/1988. Possession certificate was also given to the first defendant and in the name of the second defendant with the consent of the plaintiff, as the said amount was arranged out of the joint and nucleus shared by all plaintiffs.
How do they substantiate this?
He doesn't. There are only 4 documents placed with the plaint. 2 are the sale deeds, my vendor's sale deed, my sale deed. 1 is a Kata certificate which shows my name. 4th is the family tree which does not bear any familial connection between the plaintiffs and the defendants. Insofar, I will just point out, insofar as the question of limitation was concerned, an Order 7 Rule 11 was filed, came to be rejected. Coordinate bench of this honorable court has held ex facie that it is barred by limitation. The suit is barred by limitation. Interim order has been passed, staying all proceedings in the suit. Of course, that doesn't come in the way of the injunction that's already been passed. Now, the learned trial court says there is no prima facie case in favor of the plaintiff, records that the defendant has not made out a prima facie case. Defendant has only produced a sale deed.
No averment that why
Nothing.
they have not sought for a
Absolutely
partition all these years.
nothing. Zero. In fact, if your ladyship will just see the mischief caused by the plaintiff, please see at page 51, the cause title. 1, 2, 3. Please see the address. The address just says residing at Chikbalapur. This is not a plaint that could have passed muster even at a scrutiny stage. They get an injunction, they have been absent.
Taken such a, you're not taken such ground before the trial court that how can there be a?
We did. In fact, I was very circumspect to say this. It's a learned trial judge who says, look, place this, there seems to be an error in the family tree. You place it with your memo of citation at the time of arguments.
Please come to the impugned order. Now let's understand the
Please.
reasons.
Your leadership may straight away come to paragraph 7 of the impugned order at page 29. As per the plaintiffs and defendant number 1 are the sons of so-and-so. Defendant number 2 is wife. Plaintiff and defendant number 2 are being the joint family members. Plaintiffs are defendant 1 and 2 constitute Hindu undivided joint family practice under Hindu Mitaksara law. To substantiate the relationship, the plaintiff have one notarized genealogical tree dated 7/9/23. The suit is dated 26/7/23. The family tree produced with that is completely different. Thereafter, The same noting is made at paragraph 8 at page 32. At page 33, if your leadership is at page 33, please see the fifth sentence from the top, which says, further, it is also worth to note neither first defendant nor second defendant have disputed their relationship with the plaintiff. No summons has been served on these defendants.
Yes. Please come. Your which defendant? Third.
Please,
The third
fourth,
defendant.
fourth.
Fourth. Your vendors are 1 and 2.
1 and 2. Third is my husband who was deceased. He bequeathed the property to me before his passing.
Agreed with orders passed in I number 1 and 2. Invoice number 4757 of 2023 dated 6th December 2023. The defendant is before this court. The plaintiff had filed a suit for, the plaintiffs have filed a suit for declaration that the sale deeds that are executed in favor of defendant number 1, 2, 3, and 4. Defendant number, no, not, defendant number 3 and 4.
3 and 3. Defendant 3.
Defendant number 3 and the subsequent deed, that is not question.
No, the subsequent, the first deed is between defendant 1 and 2 in favor of 1 and 2. Then between defendant 1 and 2 in favor of defendant 3, who's my husband. Yes.
No, they've sought cancellation, the defendant number 3 must be,
Oh,
they've sought cancel, and also cancellation of the sale deed executed in favor of defendant number 3. The case of the plaintiff is that the property was purchased in the year 1916,
1988.
in the year 1988 from a society by the defendant number 1 and 2. At that point, who are none other than the brothers, who are none other than the brother and his wife of the plaintiffs.
Purportedly, we don't know. We don't know if they are.
What they say.
That is what they say.
It's a plain government.
That's right.
That his wife and his brother, according to them, as he was not in a position to pay such a, shut down such an amount, they have given, and it is a joint family property and they are entitled for partition. The defendants have no right to execute the sale deed in favor of defendant number 3. As such, they have come before the court seeking declaration that the said sale deed executed by D1 and D2 is not binding on them, and also, and this also partition of the joint family property. Initially, the court had granted injunction restraining you from alienating, restraining the defendant from alienating the property. Thereafter, the defendants have filed their written statement, have also filed their objection, filed the written statement, and have filed IA number 3.
I number 2.
I number 2 to vacate the said order. It is the case of the defendants that their vendors have purchased the property in the year 1988 and the case, and it was sold to the defendant number 3 in the year 1991. And defendant number 3 in turn has executed a will.
Has executed will, that's right.
Has executed a will in favor of defendant number 4, who is his wife. They have been in possession of the property from the year 1991, from the day they purchased the property. It is the case of the defendants that the suit itself is barred by limitation. When they're seeking cancellation of a sale deed dated 1991, the 1991, it's barred by limitation, and in the plaint, there was no averment with regard to when they have come to know about it, and nothing was pleaded in the plaint. It is also the case of the defendant that as it is a public document, as per section 3 of the Transfer of Property Act, that amounts to constructive notice, and even on that ground also the suit is not maintainable. And they filed when they have filed an IA too, along with the objections, the trial court had dismissed the said IA filed by the defendants, holding that whether the property is an ancestral property or not, whether the defendants have any right to execute the sale deed in favor of defendant number 3. All these aspects have to be decided by the court after a full-fledged trial. And a full-fledged trial. In the meantime, with the defendants alienate the property, it frustrates the relief that is sought in the plaint, in the suit, and had granted the injunction and made the injunction absolute. Agreed thereby, the appellant defendant number 4, 3 and 4 or 4.
4.
4 is before this court. Land counsel, defendant is no more, 3 is no more.
3 is no more. 1 and 2 have not been served.
The land counsel appearing for the defendant number 4 submits that when an injunction petition is filed in the seeking, when an interim injunction is sought, he has to show a prima facie case, balance of convenience and irreparable loss. When they're seeking a cancellation of a sale deed dated 1991, a declaration that the sale deed is not binding on them. And according to the land counsel, they're not made out any prima facie case. There are no pleadings in that regard, either in the plaint or in the IA that is filed, about their knowledge about the said execution of the sale deed. He submits that initially when they find the genealogical tree, in that the name of their vendor, the defendant's vendor's name is missing. Thereafter, adding his name also in the said tree, they file the another tree before the court. It is also pointed out that in the plaint, they do not mention the address of the plaintiff, except stating that they're all residents of Chikbalapur town. And counsel further point out that all the plaintiffs are aged 85 years, 82 years, 79 years. They've never stated why they have not sought for a partition much before, and when they have come to know about the deed, the sale deed dated 15/11/1991. When with all these kind of vague allegations and vague pleadings, when they have sought for injunction, the court, without considering any of these aspects, had granted injunction and made the same absolute by dismissing the vacate application filed by the plaintiff. It is submitted that the order passed by the court is not only contrary to law, but also to the pleadings in the court, had in fact fastened the burden on the defendant and basing on the defendant. Next part. The notice is as per the order passed by this court. Then the petitioner the appellant had taken out notice on the respondents by way for substituted service. As for the order of this court dated 12/7/2024, as such the notice and the same is filed before the court, and this court has held that the notice to the respondents are sufficient. It was held sufficient. in respect of 4 and 5, taken out the substituted service of notice and that's held to be sufficient. As far as respondents 1, 2, 3 are concerned, this court has permitted them to take out notice on the counsel appearing before the trial court. And the notice is served and a memo is filed before the court in view of the same. As the notice, all the respondents are served and no wakalat is filed on their behalf, having heard the learned counsel for the appellant, there is entire material on record. The suit is filed for partition and for cancellation of the sale deeds. All the plaintiffs are the senior citizens. It is their case that the plaintiff, the defendant number 1 and 2 have purchased the property. For the purchasing of the said property, they have contributed, they have given the amounts. And according to them, it's a joint family property. And the property was purchased by the plaintiff in the year 1985, which was sold to the defendant number 3 on 1991.
1988.
It was on 1988 and was sold to the defendant on 1991. This court has perused the plaint. In the entire plaint, there is no whisper about how and when they came to know about the sale deed that is executed in favor of defendant number 3. As rightly pointed out by the learned counsel for the appellant, in the plaint, they have not even furnished the address of the plaintiffs, except stating that they are residents of Chikbalapur town. When they have come before the court seeking a cancellation or a declaration that the sale deeds of 1991 are not binding on them, and they want an injunction restraining the defendant from alienating the property, they have to make out a prima facie case, considering the submission of the counsel and a perusal of the order plaint. It discloses that it demonstrates that the plaintiff had failed to make out a prima facie case. Prima facie case. When that is, and all as rightly argued by the learned counsel for the appellant, in view of section 3 of the Transfer of Property Act, as it is a public document, the defendants have a constructive notice, the plaintiff had a constructive notice of the same. On all these, basing on all these, this court is of the view that the plaintiff had failed to make out a prima facie case. And in spite of, in fact, when the defendants are in possession of the property, right from 1991, the balance of convenience is in fact more in favor of the defendant number 3 and 4. And the trial court, without considering all these aspects, have granted injunction, and then you have the above discussion. This court deems it appropriate to set aside the order dated so and so. And accordingly, the injunction that is granted in favor of the defendant is in favor of the plaintiff is vacated.
You lack one submission, you lack.
No, allowed. Yes. Yes.
Serial number 37, your lordship.
Why?
Some settlement is going on, my lord.
37.
37.
Is it so?
Just negotiated settlement talks.
It is submitted that by both the council that the settlement talks are going on. When do you want?
After 20 days, my lord, please.
Pose this matter on 30th of September. Yes, next.
Serial number 20, my lord.
No adjournments. It's only because it's a settlement the court has heard.
Okay. 37. Balakrishna Sastram.
30th, madam? 30th September.
31. Serial number 31.
230 के पासवर्ड माफी प्रस्ताव
Two thirty ಬರ್ತಾರ.
ಪಾಸ್ವರ್ಡ್ ಮ್ಯಾಟರ್ಸ್ 230 ಪ್ರಸ್ತಾವ
230 ಗೆ ಇಷ್ಟಿದೆ.
ಅದಾದ್ಮೇಲೆ ಪಾಸ್ವರ್ಡ್ ತಗೊಂತಾರ ಅಥವಾ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ ಲಿಸ್ಟ್?
Some 2 days before pass hours na end of the list ಅಲ್ಲಿ ತಗೋತಾರೆ.
ಇವತ್ತಿನ ಪಾಸ್ವರ್ಡ್ ಬೆಳಗ್ಗೆ
2:30 wait
ಆನ್
ಈಗ
ಮಾಡಿ.
ನಾನು ಒಂದ್ಸತಿ ನಿಮ್ಗೆ ತೋರ್ಸ್ಬಿಡ್ತೀನಿ ನೋಡಿ.
ಹಾ.
ನಾನು ಆಪರೇಟ್
ಇನ್ನೊಂದ್ಸರಿ ಇರಿ ಇವಾಗ ಇದು ಸ್ಟಾರ್ಟ್ ಆಯ್ತು.
ಎಲ್ಲೋ.
ಇವಾಗೆಲ್ಲ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು
ಹ್ಮ್.
ಆಯ್ತಾ. ಇವಾಗ ನಿಮ್ಗೆ ಬೇಡ ಅಂದ್ರೆ
ಇದು ಎಲ್ಲಾ ಸುಮ್ಮನೆ ಸಿಂಪಲ್ ಮ್ಯಾಟರ್ಸ್ ನಾನು ಮೇಡಮ್ ಹತ್ರ ಸಂಜೆ ಸಜೆಷನ್ ಇದು ಕೇಳ್ಕೊ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್.
ಮೇಡಮ್ ಹೇಳಿರೋದೇ ನಾವು ಬಂದ್ವಿ.
Court officer, Hello. Court officer. Hello. Court officer. Hello. Court officer.
ಸರ್ ಹೇಳಿ ಕೇಳಿಸ್ತಾ ಇದೆ.
List 1 serial number 8 pass over ಆಗಿದೆಯಾ ಮೇಡಮ್?
ಆ 8 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಸರ್.
Okay, thank you.
Court of sir, list 3 call ಆಯ್ತಾ court of sir?
ಲಿಸ್ಟ್ 3 ಇವಾಗ 2:30 ಅದೇ ಇರೋದು.
Okay, thank you, thank you.
ಸರ್ ಸರ್ ನಾನು ಏನು ಹೇಳಕ್ಕಾಗಲ್ಲ. ನಾನ್ ಐ ಕಾಂಟ್ ಟೆಲ್, ಐ ಕಾಂಟ್. ನಿಮ್ಮ ಲಿಬರ್ಟಿ ಅದು. ಇಸ್ ಯುವರ್ ಲಿಬರ್ಟಿ, ಯು ಸಬ್ಮಿಟ್.
May I make a submission? May I make one submission, my lord? List 2 serial number 2, my lord, I'll comply the office submission within due course of the day. I may be given the access file. Access to the file may be given, my lord. I'll comply with it.
The list will be called now. You can wait for that.
Lordships kindly. Memo for
Things now.
posting, my lord. The urgency is this.
No, if there is urgency, you should have mentioned it in the morning.
Lord, I have obtained the copy at 12 o'clock in the afternoon, my lord. There's an order, my lord, notwithstanding my caveat petition filed. There's an order passed by this honorable court, my lord. Lordships have directed me to file an IA. I have already filed an IA to that effect. Lordships may have it tomorrow. Kindly.
When is the order passed?
6/8, and I have obtained the copy today, my lord.
So it's not that whenever you obtain the copy, you'll come and mention. There's a procedure, is it not?
My lord,
Tomorrow,
my
make a
anticipation, my lord, is section 14 is, my lord, invoked.
Tomorrow, make a mention and give the slip. It will be considered, not this time.
Yes.
Yes.
2:30 list number 3 for order serial number 1. Smith Hulla, Smith Rajendra.
Yes.
What is compliance of office objection on the
Appellant has to.
No representation for the appellant. Post for dismissal tomorrow. The same list. Yes.
serial number 2.
Office has raised an objection is the subject matter is more than 15 lakhs. It lies to division bench. It's posted before division bench. And one office
So
objection
brings
is
an
there. my
objection
lord.
that the appeal is valued more than 15 lakhs. The matter has to be placed before the division bench. The registry is directed to place this matter before the division bench.
One minor office objection is there. Not signed the second set. If also be permit me, I will comply it now itself.
Yes.
Serial number 3. Serial number 3. Madraj B. Gunjal.
There was a objection raised with respect to the EA prayer not tallying. I'm filing a fresh application. The copy has.
File it before the registry, then comes for the appellant shall comply with the office objections within a week, the same default order. A week's time is granted, not within a week. Yes, next.
A short date may be given, my lord, has to be
It
considered.
has to come up for admission for this matter on 23rd of September. Yes.
Number 4. Yes, Prakash.
For the petitioner. Because there are two appeals raised that is that of translations, but that may not really be required. For the reason being that this is a petition filed under section 276 of the Succession Act. Now the learned judge does, despite there being no contest, dismisses my petition, saying that.
No, that's on the merits of the matter. Let's see what are the objections and why it is not
the
relevant. We'll see.
Document number 6 and 8,
1 minute.
they
1
want
minute.
translated copies.
Office objections are compared with regard to office objection, that is typed copy of so and so. Counsel for apparent has submitted for the annexure 8, the first page is in manuscript and others are in digital copy. So where is that page number?
Page number, my lord, is 68. 68 is where the only the manuscript is there. It's written in hand. Otherwise, all other pages are in printed copies.
The office objection for overrule. Pose this matter for admission.
You actually consider a date, no? Kindly consider a date.
26th.
Oblige, what's your good?
Office objections are overruled. Yes.
Till number 5. K.S. Ganesha. Maintenance.
You that. No representation for the petitioner. Both this matter for dismissal tomorrow. Yes, next.
Till number 5. 6. Till number 6. P. Srinivas Kumar.
The in the present RPFC, the order impugned is passed in I number 2, where the court had granted an interim maintenance of rupees 10,000 per month. Against that, the RPFC has been filed. The registry has taken the objection with regard to maintainability of the petition against the interlocutory order. The office objections are sustained and the petition is dismissed with the liberty to the petitioner to avail the appropriate remedy. Yes.
Till number 7. Raghavendra Reddy K.
My lordship,
KV.
in this case, I am appearing for the respondent. I have filed an application for seeking direction to release the maintenance amount which is deposited by the petitioner before the trial court.
Where is the petitioner first?
Lordship,
IA number 1024 is filed by
filed
you.
by me.
What their office objections on
Office
that?
objection is the copy is not served. It is already served, ma'am. Served.
We'll have it tomorrow, is not
Please.
tomorrow.
Yeah,
No
I have the
represent-
acknowledgement to it is already served.
No representation on behalf of the land council for the petitioner, land council the respondent. Submitter is already served a copy on him. Yes, next.
Till number 8. Arun Govindraj. Kavita D.
Submitting the affidavit copy. We have applied for the affidavit, madam. Given a copy. to the-
Statement of objections. Each page has to be signed by the council.
Yes,
But
madam.
this matter had come up in chambers day before yesterday. But the mother agreed to hand over custody to the father for 1 month.
Yes, yes. File a memo.
Yes, madam.
Affidavit is filed.
Affidavit is filed. We are ready to give the custody for one.
So in the light of this, we can dispose of this.
Lord, I have only one, Lord, matter could be taken up in October. Also one request, Lord. There's some condition that the mother wants imposed that the father should take care of the academic expenses of the child.
Where is that?
5A,
The petition shall take care of the whole response.
including an academy.
There's a difference between expenses and academics.
Very. Yes,
Said was, shall take care of the whole responsibility of my Kavi,
Yes.
including her academics.
yes.
Hmm.
Look, the only thing is, I don't know where she stays because we were staying in the same apartment complex until about 4 months ago when she shifted. I don't know where the child studies nor where the respondent stays. If she furnishes the details, then
But she must have stated so. I so and so.
Whitefield. But where the
Residing
child
at,
studies, I don't know.
Villa VP 13. Her address is here.
Where the child studies, I don't know. Child was studying in Kumaran School in Jayanagar until.
No, you'll be picking up the child from then once, when she's there, my wife.
That court's mic is muted, my lord.
Tanvi C.
Yes.
B.
My lord, I
A
appeal-
week's time is granted for complying the
But-
office objections, default clause.
My lord, office objection is regarding translation, my lord. The relevant document, my lord, only
We
one.
are not audible.
Sir, you were
My lord, it is only translation, my lord. Office objection was translation. One of the document for consideration of the interim prayer I got ready, my lord. Translated copy is ready with my colleague. If your lordship permits, my lord, I'll argue, my lord. For consideration of interim prayer, the other document, my lord.
No, not at this stage, not at this stage. Let it come for admission.
My lord, may
Uh,
file the,
Then council submits that, file it in the section. Then council submits that they'll comply with the, then council for the writ petition submits that they'll comply with the office objections. Pose this matter on 20th.
much obliged, my lord.
Yes, next.
Till number 10. General
Fill it in the register.
Gaule.
Verifying affidavit has not, the office has raised the objection.
You'll file,
File.
file it in the section. It is submitted that during the course of the day, they'll comply with the office objections. If the office objections are complied with, pose this matter for preliminary hearing on Friday, 20th. Even the other matter also, Friday is 20th. Yes,
Till number 11. Praveen S.
the council is appearing, already you're appearing.
Appearing for respondent. in this case,
The
my lord.
office objections or the respondent is already appearing.
My
That's
lord, in fact, they were appearing on the last dates also, they were taking adjournments. And my lord, in this case,
It's
they,
coming up for office objections. We will not hear it. The counsel for the respondent is already on record. The office objections are overruled. Pose this matter for admission for preliminary hearing on 20th. Yes, next.
Till number 12, non-compliance third time. V. Anand, Mahesh B.
Caveat respondent.
KVJ.
This matter was already once dismissed for non-prosecution.
Pose for dismissal. No representation for the appellant. Counsel for the respondent is present. Next.
Dismissal tomorrow, ma'am.
Dismissal tomorrow. Yes, 13.
Till number 13.
Same 13,
Yeah.
same order. 13. For
Till number
dismissal.
13. 14. Girish Kumar CS.
Just for 1 week's
14.
accommodation. 14.
A week's time is granted. Same default clause. Is 15.
15.
Dismissal.
Sanjay. 16. Sanjay ji,
Dismissal.
cell number 17.
Take that.
This one.
It is stated that on IA number 2, the trial court has already passed an order, hence the petition has become infructuous, and hence the present memo is filed. Seeking to withdraw the appeal. Memo is taken on record and dismissed as withdrawn. Yes, next 18.
Cell number 18.
Kindly grant a week's time for.
Yes, week's time, default. 19.
Cell number 19.
Appearing for appellant, praise for 1 week time.
Yes. Same.
Cell
20.
number 20.
Appearing for appellant.
Kashyap and Nayak.
My lord, I filed illusory wakalat on behalf of appellant on 27/8, my lord. The name of Kashyap bin Nayak might be deleted and Suraj Sampath name might be added, my lord.
So and so, registry is directed to pin the name of so and so.
name
Give
is-
her, give the name, write in a paper and give. So and so,
Might be
a
granted.
week's time is granted for complying the office objections. Yes, next 21.
Number 21. Fourth time non-compliance.
Yes, dismissal,
Order.
dismissal,
Cell number 22.
same order.
Cell number 23.
Same. 23 you appear.
My lord's 1 week's time. will be
Yes, a
granted.
week's time on in 23.
Grateful.
Cell
Yes,
number
24.
24.
Appearing for respondent.
Sampath ye.
My lord, appearing for petitioner for appellate. My lord, there is a memo for withdrawal.
Give that.
Please.
Take that.
My lord, we approached this court on pecuniary jurisdiction, but of 10 lakhs, but we have to go to the civil court now. So we seek the leave of this court to withdraw the appeal.
2023, you have taken this much of time to realize it. Then why should the court give liberty to you? Let your senior come and argue, no. 2023 matter, now you realize. Don't comply with the office objections, don't go before the court for 4 times for for complying with the office objections. Yes, 25, pose this matter on 21st, not 21st,
20.
on 24th. Yes,
For 25.
Yes, for the petition.
To the
A week time, ma'am.
yes, week's time.
cell number 26. 26.
Dismissal,
Jagdish.
dismissal.
Cell number 27.
For petition, my lords, I seek a week's time, my lord, to comply with
Yes,
office
week's time
objection.
on in 27.
Oblige, my lords.
In,
List number
He was-
1 matter.
no, he was mentioning this one. What is he asking?
I appear for appellant. I'll comply within due course of the day. Few office objections are minor.
Delete from the caption for dismissal, then council is permitted to carry, what is this? The then council is permitted to comply with the office objections for this matter next week. The default order. Yes, next.
At the
No passwords, call the list.
list. Cell number 18. List 1, cell number 18. Chandana P. Somana. Abhinav Ramanan.
For the appellate,
Yes.
I comment.
Yes.
My lords, the appellants herein are the lessee in suit scheduled property of the respondents. And the suit and the lease is not disputed. It was in continuous, we were in continuous possession from 2001. And subsequently in
What is the suit for?
suit for permanent injunction.
You are the plaintiff.
Plaintiff, yes, ma'am.
Oh. Your injunction that is sought is declined.
No, we, in our IA, our injunction, we got a temporary injunction. Pursuant to that, close on the heels of passing that IA number 1 order, they filed 2 applications, IA number 2 and 3, under 151 and 39 Rule 2. IA number 2, my lords, gets
both have a common order that was passed, IA number 2 and 3. Pursuant to that, we approached this Honorable High Court and challenge IA number 2. And IA number 2 gets dismissed. Thereafter, IA number 3 is the impugned order herein. My brief facts of the case is this, my lords. We are the
So, I number 2 and 3 are there. What is I number 2?
IA number 2 is to demolish the wall abutting our signage board. They get the wall demolished. And then in IA number 3, they ask for a direction from the court to remove the signage board. And they obtain that direction also. IA number 1, which was passed, we got an order asking them, restraining them from interfering with the peaceful possession of the item schedule, which is clearly mentioned in our prayer and it was observed. There are several findings to that effect. And everything was ruled in our favor. Close on the heels of passing that order, these two IAs came to be filed. My lords, they have not filed any counterclaim. No counterclaim, nothing. And this was placed before this honorable court through a writ petition. We get a order in dismissing the IA number 2. IA number 3 is for removing the signage board, which they've automatically taken law into their own hands, removed the signage board.
Let's see the order.
Well, the impugned order is at page 17.
Yes.
May I please take your lordship's kind attention
So
to?
we are only concerned with I number 3 now.
Yes, ma'am. My lords, may I kindly turn your attention to
Come to reasons. Come to reason.
Yes, ma'am. It's para 8. So one of the reasons is that the signage board was removed. It is further alleged by the applicant that there was no hoarding on the first floor as on the date of filing the suit. And even the interim order passed by this court did not grant any permission to the plaintiff to alter the first floor and to put up additional hoarding. The applicant has further urged that they intend to start their own business in IA suit scheduled property, and no brand is ready to grant them a franchise unless the board put up by the plaintiff is removed from the first floor, and therefore it has become necessary to remove the same. It is further urged by the applicant that the plaintiff has already put huge sign brands measuring over 40 feet in length on the ground, which is having sufficient visibility in the area. And the plaintiff is also not paying any consideration with respect to hoarding put up on the first floor, and the license to put up the said hoarding in the first floor has also been terminated by the defendants after the hoarding of the plaintiff was removed by BBMP by notice dated 12/10/2023, my lords. My lords, may kindly have this date because it is crucial to this effect, to this list. To further substantiate this aspect, the defendants have also produced a copy of the notice issued by BBMP authorities in this regard. Therefore, the defendants have urged that since the plaintiff is in possession of the ground floor portion and has sufficient large sign boards on the premises wherein their business is carried on. My lords, I've been led by senior counsel. He's appearing through EC.
Yes.
May I seek your lordship's leave, my lords, to continue the matter?
Yes.
Lords, the gamut of this lies in a very narrow compass. Lords, if your lordships were to see what is the Schedule 2 property for which the present suit has been filed, lordships may kindly take the plaint. Lords, your lordships will get it. Lords, at page number 30. This is the plaint. And your lordships will get the relief at page number 35. The relief itself is in respect of item number 2 scheduled property. And the description of item number 2, my lords, is at the bottom of the page. Lords, all that piece and parcel of commercial property bearing number so and so, situated at Ballari Road comprising ground floor, and lordships may mark the next 2 lines. The signage on the first floor, totally measuring 2,300 square feet along with the right of parking on the open area adjacent to the demised premises and bounded on so and so. Lords, what I am requesting your lordships to kindly mark is this signage on the first floor totally measuring 2,300 square feet.
No, it is now, it is injunction is in respect of Ground
It's
floor
the
and
very
first
same
floor.
property, same signage. There is no other property. This is the very subject matter for which we are now having an adverse order.
Building
Which is
consists of 2 floors or one floor?
Notice the lease consists of ground floor and a right of signage on the first floor. And this is the categorical finding which has been given while disposing of IA number 1 of 2023, which the Lords will kindly get. Lords may kindly take to the order dated 16/11/2023.
Where is it?
Lords will get it,
Page 58. Bharat.
please. Page 58.
Hmm.
Lord, this is on contest. Lords may kindly take page number 67 straight away.
Yes.
What your Lords will find is the findings which is specifically recorded at page 67. Lords, I just take your Lords from paragraph number 11, about 7-8 lines from the bottom of the page. Therefore, from the rival contentions of the parties, it could squarely be held. Applicant could make out a prima facie case for trial on merits. However, mere making out a prima facie case is not sufficient because the applicant is further to make out a prima facie grounds even to seek for temporary injunctive relief, which is well-established position of law. And perusal of the materials before the court by the applicant, it is prima facie revealed that the plaintiff company as a lessee under the defendants till filing of this suit continued to pay the regular rental amount to the defendants. It is further relevant to note that the document produced at Annexure B by the plaintiff, which is the letter dated 19/12/2020, issued by the plaintiff company to the defendants, indicate that the tenancy between the parties was continued and the defendants were shown to have allowed the plaintiff company to remain in the western portion of the scheduled property of the surrender of the first floor portion to them. The said letter at para 3 indicates that as per the discussion between the parties, defendant had agreed not to alter the front signage.
1 minute, Ms. Senior Counsel.
I'm the
Here the
plaintiff.
important aspect is the plaintiff company to remain in the western part of the scheduled property after
Yes.
surrender of the first floor portion to them.
Yes. Next portion.
That is there. Now you're not in possession of the first floor property.
Lords, we are not in possession of the first floor property, but what was reserved was the signage. The right to use the signage in the frontage of the building on the first floor is the subject matter of the suit.
It was erected on the first floor.
It is erected on the first floor. So the right to use the signage is what is the subject matter of the suit itself, which is item number 2 property other than the parking space which we have referred to. Now, my lords, what the court records in the first instance, if your lords were to see, my lords, I just read 2 sentences further. To remain in western portion of the scheduled property after surrender of the first floor portion, the said letter at para 3 indicates that as per the discussions between the parties, the defendants had agreed not to alter the front signage of the showroom of the defendant plaintiff company. There is no specific denial or dispute with regard to this letter by the defendants. Therefore, from the prima facie document, it is shown that even after the plaintiff surrendering the first floor portion and additional portions of the schedule item number 1 property to defendants, it was permitted to put the front signage of their showroom. Photographs which is produced at page number 14 of the plain documents clearly indicate that the site signage of the plaintiff showroom was still continued to remain on the ground floor as well as on the portion of the first floor. Then your lords may kindly take the next paragraph. Lords, I just read, my lords, quickly. The document produced at D, which is the copy of the bank statement of the plaintiff company, once again indicates the regular payment of the rental amount to the defendants. It is pertinent to note that this bank statement shows payment of rent till 3/10/23 and the subsequent document at page 51, which is extract once again, they indicates the payment of rent of 15,000 to the defendants towards the signage till August 2023, which is after the surrender. It is also relevant to note that the applicant also produced a copy of the complaint dated so and so. Notes, having said that, at para 14, notes the second sentence. As rightly pointed out, notes it starts, para 14 starts like this, as rightly pointed by the learned counsel for the plaintiff. Correspondence letters between the parties which are produced before the court prima facie indicate that implied admissions by the defendants of the continuation of the position of the plaintiff over the suit property. No doubt the defendants have issued legal notice to the plaintiff calling upon them to vacate and surrender the possession of the property to them, but it is not their contention. They have already initiated the proceedings. Then notes, I'll skip and come to paragraph number 16. The letter dated 29/3/23 produced by Annexure E by the applicant once again discloses the considering the good relationship between the parties. Plaintiff has agreed to hand over portion of 50% of the ground floor area, 50% of the ground floor board, and 50% of the floor board. Also, the agreement between the parties in regard to the renewal of the amount of 1,20,000 rupees. Notes it continues in the same way. Notes then para 17, which probably notes concludes on these findings. No doubt it has been repeatedly contended by the defendants that they have not removed the disputed holdings put up by the plaintiff on the first floor of the scheduled property, and according to them, it was the act of the BBMP authorities to substantiate the defense. No supporting materials are produced before the court. If really the said authorities had done the said acts, certainly they would have issued prior notice to the plaintiff company. In this regard, calling upon them to remove such holdings, which if found to be legally put on scheduled property. Therefore, all these disputed issues involved in the case certainly require detailed inquiry. Till then, so long as the defendants have not initiated eviction proceedings against the plaintiff company to seek vacant possession of scheduled property, plaintiffs are entitled to
Before you proceed further, you are
Lordships.
in occupation of the ground floor.
Yes.
So first floor, you have given portion to the owner's owner
Yes,
or.
Lords. Yes.
Now, if you put up a signboard on the second floor, what will they do? For the first floor people, what they will do?
Lords, what they will do, Milords, is something which was to be thought about. When I surrendered, this was the condition with which I have surrendered. Lords,
There
the
is like-
surrender
is it
does
a-
not
is
take
it
place
a written
unconditionally.
agreement? Is it a written agreement? No.
Lords, that is the letter which is being referred to, Milords. Lords will
Where is
kindly
that?
come. Milords, kindly come to paragraph number 12. The finding is given in an earlier instance.
Yes.
On perusal of the materials placed before the court by the applicant, it prima facie revealed that the plaintiff company as a lessee and the defendants still filing of the suit continued to pay the regular rental amounts to defendants. It is further relevant to note that even the document produced at Annexure B by the plaintiff, which is a letter of 9/12 issued by the plaintiff company to the defendants, indicate tenancy between the parties was continued and the defendants were shown to have allowed the plaintiff company to remain in western portion of the scheduled property after surrender of the first floor portion. The said letter at para 3 indicates that as per the discussions between the parties, defendants had agreed not to alter the front signage of the showroom of the plaintiff company. There is no specific denial or dispute regarding this letter by the defendants.
Yes.
Now, having said this, now, Milords, what happens? This order has become final. Lords may kindly come to the operative portion of the order.
Yes.
At page number 76.
Yes.
The defendants or anybody on behalf of are hereby directed by an order of temporary injunction not to interfere with the portion of the plaintiff or item number 2 scheduled property in any manner till the disposal of the suit.
Yes.
Notes, I have already brought your lordship's notice at page number 35, the item number 2. Now, notes what happens. The defendant files an application, IA number 2, seeking permission of the court to remove the wall on which the hoarding is standing. And IA number 3 is filed saying that a mandatory injunction should be issued that I should remove the board, the signage board which is put up on the first floor. Both these applications comes to be allowed. And this time, diametrically opposite findings are recorded by the trial court without reference to the findings which is recorded earlier in this proceedings. And what further happens is, IA number 2, which was a direction to remove the wall, was challenged because it was an application filed under 151 that was challenged in the writ petition.
Yes.
That is writ petition number. There is a memo which my colleague will be giving.
Before that,
Which is
can you please come to the order and then we'll go to that memo?
Lordships.
What is the order? Please come to para number 8.
Lordships may kindly come to the order which has been passed at page number 77.
No, impugned order is in page number 21.
Page number 21, my lords. The application is at page 77. What is the relief sought for?
Yes.
But the relief sought for is that the wall should be taken off. They should be permitted to remove the wall. And the mandatory injunction is requested that I should remove the signage. Now your lordships will kindly see what is the orders passed at.
No, he
Pardon?
didn't say all that. There is no mention about the signage in this. 77.
Lordships may kindly see, my lords, IA number 2 is filed for removal of the wall. IA number 3, my lords, at page number 83.
So no, as far as this 77 is concerned, what is the difficulty?
Notes IN number 77, the writ court has set aside the orders because common reasons are assigned by the trial court.
Hmm.
The writ court has already set aside the orders on IN number 2.
It's already set aside.
Yes.
Hmm. Yes.
Page number 83, my lords, is the relief sought for in IN number 3.
Yes.
Directly to remove the holding. It's essentially the signage. That's. Now, your lords will find the findings which is given, lords, at commencing from page number 25. Lords, para 11 to be specific, my lords. Para 11 at page 24.
Yes.
It is relevant to note that Annexure B letter, which is relied on by the plaintiff, is letter which was addressed by the plaintiff's representative to the defendant. Though it is stated as per the discussion, difference was undertaken not to alter the front signage of the showroom, but there is no specific mention about the said signage board put up on the first floor portion, even in this letter. Moreover, there are no materials placed before the court to show that this request made by the plaintiff to continue the fresh signage board of the first floor portion was accepted by the defendants, and they are permitted the same to continue the signage board on the first floor, even after handing over the possession of the floor to them. Under the circumstances, the self-serving letter. Note, this is the very letter which has already been relied upon. A finding has been recorded. Note, this finding becomes res judicata in the subsequent stage of the same proceedings. Note, at the convenience, notes of the applicants, it is not permissible to record diametrically opposite findings. And then the court finds, notes, kindly have a look at paragraph number 12. Note that removal of the board was already brought to the notice of the court that the BBMP had never undertaken this exercise. Court says BBMP had not done it and gives an order of injunction, as a result of which the signage is put back. Now the court says, I did not permit you to put the signage back, therefore you remove it. Para 11, Milords, para 13.
Quote at para 12, that is about 5 lines from the bottom.
Lordships.
That finding is, it is clearly indicated that there was no
This
signage
is
board.
on the, as rightly pointed out by the learned counsel for the defendants, as per their own document of the plaintiff, which are produced at page 60A, which is the photograph, it is clearly indicated there was no signage board on the first floor as on the date of filing of the suit. This is essentially what is mentioned, Milords, in the earlier orders of the court. Lords, your lordships may kindly see, Lords, if your lordships were to juxtapose this with the earlier orders at page number 70, Milords. Yes. Lords, at page number 70, bottom of the page. Kindly juxtapose this with page number 70. This is not a finding, Lords, which is in any manner disputable because the court has recorded that finding. Page number 70, Milords, 70, the bottom of the page.
Before that, please come to the plaint again.
Please,
Page
Milords.
number, plaint.
Page number 33. There is a very specific reference to this issue, Milords.
Please, in the plaint, please refer to that, point out to that particular paragraph where you mentioned about this.
Para 11.
signage board.
Para 11. That the same was removed is referred to in para 11 at page number 33. An FIR is also registered in that regard.
So according to you, as on the date is removed.
It is removed. As on the date, the cause of action for filing of the suit was because they had removed this signage board which we were entitled to enjoy and occupy and put our signage.
That made
The
you to
court
file a
considers
suit.
this issue and says, that's what the defendant did was they came up and said, we did not remove the signage, BBMP did the removal. The court said that this cannot be believed. The signage was in place and you people have removed it because BBMP has not removed it. Court records a finding with reference to the earlier photograph saying that the signage was there in place. Subsequently, it has been removed. Therefore, you are injuncted not to interfere with the place where the signage is put up. So we put up the signage board once again. Now the court says, I did not permit you to put up the signage. The reason why I came before the court not stands frustrated. Now the suit itself stands frustrated because of a subsequent order which has now been passed by the court. Whereas there is nothing for me to pursue in the suit.
What the court is not able to understand is now during the pendency of the suit, you have vacated the first floor.
Notes, it is not during the pendency of the suit that I have vacated the first floor. Notes, it is even before the filing of the suit, we had vacated the first floor with a clear understanding that the frontage of the first floor signage of 2,300 square feet is available to me. This is the right which I am seeking to enforce by virtue of the letter dated 9/2/2023, which the trial court records a categorical finding that we are entitled to. We are still in possession of the ground floor portion, half portion, and the signage minutes of the first floor portion. But if they don't challenge the orders or the findings which is recorded on IA number 1 of 2023, notes, is it permissible for the court to substitute its own findings merely because they come up with another application? If your lordships were to permit, I will give minutes a tabulated column of the findings recorded on IA number 1 of 23 and the findings recorded on IA numbers 2 and 3 of 2024, which is completely opposite.
No. If item number, according to you, what is item number 2? All that piece and parcel of the commercial property situated in so and so. The signage in the first floor totally measuring about
2,300 square feet. That is the subject matter. Injunction is granted for that. Common reasons are assigned minutes for allowing IA numbers 2 and 3. IA number 2 minutes is concerned, the writ court has already set aside the findings.
So ultimately, if you succeed in the suit, what you want is you are the tenant, you are the lessee in the first floor.
I'm a lessee of the ground floor having a right of signage on the first floor. If ultimately, if I am succeeding in the suit, as long as I remain as a tenant of the ground floor, I am entitled for a signage.
The lease deed says so.
No. The lease deed was for ground and first floors.
First floor is vacated.
The lease deed was for ground and first floor. Now, when we have surrendered the first floor, it is with the condition that we will use the signage in the first floor. And now this is the finding which is categorically recorded while recording findings on IA number 1 of 23. There is something called as issue estoppel. If the finding is recorded by the court, it cannot be reversed by the very same court. Res judicata applies at every stage of the proceedings. This is something which is permitted, my lords. There is no finality to an order which is passed on the application at the interlocutory stage. So every time an application is being filed, new findings can be recorded, anything can be done.
Yes.
So therefore, my lords, my respectful submission is that the order which has now been passed is mutually destructive of the findings which is passed earlier, which is not permissible by virtue of judicial propriety. It's a question of propriety, my lord, that the findings cannot be rewritten merely because there is another application with no change of circumstance, no change of materials. Number one. Secondly, my lord, there is a principle of issue estoppel and res judicata which applies at all stages of the proceedings. There is no way that this could have been redone. Number three, my lords, the orders which is common orders are the common reasons which were assigned on IA number 2 and IA number 3. IA number 2, my lords, the writ court has already set aside the findings. My lords, as a matter of fact, the court even said that as to whether the hoarding was there, wall is there, which is demolished, etc. This is to be considered after a full-fledged trial, which the court said it is inquiry. Notice what the defendant did. They went to the trial court and said, you post this matter for inquiry. So we filed an application seeking clarification before the coordinate bench, which was the writ court. Coordinate bench even clarified that this application is already disposed of. Notice your lordship is taking that order, my lords. Para 3 and onwards.
No.
Para 5, it also refers to the order, my lords, which is impugned in the present petition.
Yes.
Lord.
This order you have not questioned.
Which order, my lord? That order I have not questioned. What the dishonorable court felt was, my lord, there is a need for inquiry. I'll explain how the sequence of events, my lord. Admittedly, my lord, appellant is the tenant. My lord, the respondents are the landlords. My lord, the ground floor as well as the first floor was let out to them. My lord, they came forward with.
When was the lease?
My lord, lease in 2001, my lord. 2001, my lord, it was let out. Then, my lord, one set of documents are produced now. In that, if my lord kindly sees, my lord, they came forward. Just give that set. They came forward, my lord. Please take page number 56 in what they have produced.
Page number?
56, my lord. They came forward, my lord, with a proposal saying that, my lord, they will hand over the ground floor to us. That letter, my lord, is at page number 56. They will also hand over, my lord, the ground floor portion, and, my lord, 60 lakhs is to be paid. My lord, they violate this letter, my lord, 29/3/2023. Therefore, my lord, before the commercial court, I have already filed a proceeding for their eviction of the ground floor. What they did for, my lord, was.
In this, where is it mentioned about the signage?
My lord, please see, my lord. Signage, it is not there, my lord. What it also only
The
says.
one court is referring to?
No, civil court is referring to page number 60. Please take page number 60A, my lord. Page number 60A, 60A.
There is no 60A here.
My lord, after 60, my lord, the page number is written here, my lord, unfortunately. After page number 60, on the top, my lords will get, my lord, page number 57. Then photographs. My lord, I was just showing, my lords.
No, I think court has to write the numbers. They are not there. 57.
Yes, my lord. Then, my lord,
there is no 58.
yes, my lord, they have not written it. Then, my lords will get this photo, my lord, which is 60A. This photo, my lord, 60A is written on top, my lord. 60A. My lord, this is the photograph which they produced, my lord, at the time of filing of the suit. My lords will kindly see, my lord, entire first floor they have vacated. My lord, my lords will also see commercial space available, my lord, it is there. They retained the ground floor portion. They had the signage, my lord, Girias. My lords will kindly see Girias. Above that, my lord, there is a wall which had a hoarding, my lord. This hoarding, my lord, BBMP pulled it down because they did not have license, my lord. All over the city of Bangalore, my lord, BBMP pulled down hoardings. Now their allegation is, I got it done, my lord. That is a different aspect altogether. Therefore, on the date, my lord, the suit was filed. The signage was very much there where my lord sees Girias. On top of that, my lord, first floor, my lord, there was a wall which covers the entire first floor. There was earlier a hoarding which the BBMP pulled down. That is what is mentioned in para number 11. of the plaintiff. Then, my lord, they come, my lord, surprised that there is this understanding that they will vacate the ground floor portion also. And then they file a suit for injunction saying their possession should not be interfered with. A wholly frivolous suit because we have already filed a suit for their eviction. The reason why they filed is, my lord, after they get the injunction, on this, my lord, the first floor, they install a hoarding. The signage, my lord, which is referred to in the plaint is, my lord, Girias. Ground floor, they are in possession. First floor, admittedly, they have vacated. So, my lord, ground floor is there. Girias signage is there on the first floor. Nothing to do with the wall, my lord, which covers the first floor. Therefore, we went before the court and said, please permit us to remove this wall. Court has permitted us to remove the wall. This honorable court, my lord, passed that order saying, how could you have granted a relief in favor of the defendant? There ought to have been an inquiry on that. Now the matter is posted for inquiry. Now, after they get the interim order, what they do, my lord, is this signage is there. By showing this interim order, they go and put up, my lord, a hoarding. That, my lords, will get at page number 134. Please take 134. In relation to a portion which does not belong to them, they go ahead and put this new signage, Girias. My lights will see signage, Girias is there in Kannada and in English. On top of that, they put up a hoarding. This is nothing but a hoarding. Now, my lord, we go back to the court and say, this is nothing but harassing the landlord, overcoming what the BBMP has done. And therefore, showing the court's order, they are trying to put up a hoarding, which they call is a signage, which is not permitted for. Their intention is to harass us and to see that we don't let out the first floor, because there are other terms and conditions in writing which they failed to adhere, and we have already filed a suit for eviction. And therefore, taking undue advantage of the order passed by this court, this board is put up, larger board is put up. Now, what the trial court does, my lord, is exactly refers to that. Now, please see, my lord, in the impugned order. Please see.
No, before this, where is the letter?
Letter is, my lord, 56, my lord.
You have not disputed this letter.
This letter I have disputed.
But then in the earlier IA that is passed with the
Yes, my
court,
lord.
court records that you have not disputed it.
My lord, that is an incorrect submission. My lord, what has happened is, my lord, not disputed is, my lord, the existence of the letter is not disputed. Whether this has been complied with, acted upon by the parties is disputed.
70?
70, my lord.
No, you're saying the letter.
Yes, my lord, existence of this letter at
Which page number?
56, my lord, sorry, 56. Existence of this letter, my lord, we are not disputing. My lord, it is signed by the parties.
Page of the rent agreement dated so requested to hand off.
No, my lord, this.
No, if this agreement has to be, if they have complied with this,
Yes.
how it has to be? Come to the photographs again.
Yes, my lord. Photographs, my lords will get at page number 60A, my lord, which I just
And
now.
what is 50% of that holding?
My lords, may kindly see
50%.
58, it starts off, there's an enclosure with this letter where we've attached the photographs showing what percentage of signage board needs to be let out.
My lord, I will show that, my lord.
58, and it continues, my lord. So there's clear demarcation as to what needs to be removed and what needs to be put up subsequent to this.
No, where you have put up that board is what, according to you, is agreed as per this letter.
Exactly. That's exactly the item 2, which is about 2,300 odd square feet. And we have the benefit of the interim order. That's where exactly we've put it. Nothing more, nothing less. And the other submission, my lord, sorry for the interjection.
I'll just finish. Now, my lord, after the interim order is passed, what the BBMP did, my lord, is sought to be undone, and my lord, the wrongful advantage of the order that is.
So please stick to this letter. And why
Yes.
do you say that you have signed that? And why? How can you go back?
Lord, I am not going back on this.
Then it has to be, implemented by both of you, or whether whatever it is decided by the trial court.
Yes, my lord, but this is not the subject matter, my lord. I'll just point out, my lord. Now, my lord, that's why I'm referring to, my lord. Please see 60.
No, no. He has vacated the first floor.
Yes, my lord.
So that means this letter is acted upon.
True, my lord.
Now, the board where that is installed is exactly 50% of the building as per the letter.
My lords will kindly see, my lord, earlier, this has to be read in connection with, my lord, the letter at page number 1414.
What is the letter dated?
Letter is dated 9th December 2020.
Even after that letter, you have entered into, you have
This new letter is given.
Yes.
Now, my lord, now please have a look at page number 60.
Why should the court give a different finding?
No,
What
it is not a
had-
different finding. I'll just show, my lord. It is not a different finding at all.
No,
Lord,
while granting injunction, court has completely relied upon this letter. But the very same letter, why was it not relied on when you
No,
were?
no, I'm not
passing on?
requesting the court not to rely on this letter.
No,
This-
but you have, but the court has relied, you have not questioned it.
No, no, I have not questioned it.
So can there be a contradictory finding?
It is not
from
a
there to
contradictory
that?
finding. That's what I'm saying. The finding is in consonance with this letter. I will just point it out. My lord, please see now page number, my lord, 60A, if my lord sees.
No, 56, how it is not, that you have to tell the court first. Which part of 56 should not be looked at?
My lord, please see. My lord, 56 letter is on March 29th, 2023. This was the understanding, my lord. This letter is not disputed. Under this letter, my lord, they vacated the entire, my lord, first floor. As per this letter, and ground floor was given to them. What they were entitled to, my lord, was 50% of the signage in the first floor.
Then turn on to the next,
Yes, my lord.
58.
Yes, my lord.
No, now the photographs which you have shown to the court is at that extreme right.
Yes,
That's
my lord.
where it is.
Yeah,
And as per this agreement, they are entitled to have a signage at that place.
No, my lord, they are not in. That is what I'm trying to submit, my lord. This letter, my lord, is not, my lord, in relation to this extreme right, my lord. It is in relation to, my lord, Girias, which my lords will see at the bottom, which is there only in English.
I think we can understand this plain English than the
Yes, my
photograph.
lord.
Please come to read it. Read page number 56.
Lord,
In continuation of our rent agreement dated 31st January and various meetings held
my
between.
lord, I am
us.
not, my lord, saying anything about this. Now, my lord, if my lord sees, my lord, page number 57, my lord, 58, my lord, this signage Girias, which is there on top. My lord, there are two signages, my lord. One is,
Yes, I've seen that. One is on the right, one is on the left.
no, not this, my lord. I'm talking only about this portion, my lord. One is, my lord, on the bottom
So,
portion.
then if you're not talking about that portion, according to you, they're entitled to have a board there.
Here they were entitled to have a board, my lord. I'm not disputing.
Where? Left or right?
Right,
Left.
right.
No, that's where it is.
Yes, my lord. That the situation, my lord, position of the wall is there. They were entitled to do it, my lord. What they did was, my lord, BBMP came and pulled it down. Therefore, as on the date of filing of the suit, my lord, I am saying 60A. Please have a look at 60A. 60A, if my lord sees, my lord, there is no signage, hoarding, whatever my lords may call it. They are trying to, my lord, show the hoarding as a signage. Okay, they are entitled to, my lord, show it like that. As on the day, my lord, the suit was filed, there was nothing here, my lord. Please see, my lord, nothing was being displayed here. That is because, my lord, BBMP came and pulled it down. That is our contention. Now, their contention is we pulled it down. That is a matter of trial, my lord. Trial court will decide it. Now, my lord, admittedly, no signage was there, my lord, in this portion. Lower portion, my lord, it is there. In the higher portion, my lord, on,
No, this is not a case of injunction where the plaintiff has come before the court and said that I'll retain my, let there be, I'll retain my, whatever the board, that board and all. You are coming to the court saying that it should be done. It should be removed. The wall, I should be permitted to use the wall. They should not use the signboard.
no, my lord, sign.
You are really,
Yes, my lord.
then in his suit, how can you come up with these kind of
That's what I'm saying, my lord. This, my lord, this portion, my lords will kindly see, there is no signage, whatever hoarding or signage or whatever it is. That is because, my lord, law does not permit them to install it. They must have a license. They don't have a license.
That is a different proceeding.
Yes, my lord.
You go to the BBMP.
BBMP, my lord, has pulled
BBMP
it
do
down.
what they're supposed
Now,
to do.
after the interim order comes, my lord, they put up a signage here at this place, even when it was not there.
Court cannot adjudicate that issue in their suit.
My lord, if the court comes to the conclusion that the injunction has been wrongfully made use of, my lord, definitely, my lord, it can see. Therefore,
The court has interpreted the photographs, the agreement which is already been accepted by the court, that letter of.
my lord, all that is not in dispute. My lord, all that is not in dispute. Now, please see para 12, my lord, of the impugned order.
Can you submit something contrary to your own admission?
My lord, I am not, my lord, let them show one place, my lord, where I have admitted there was a hoarding here, my lord, or a signage here.
That he can he is permitted to have a board.
No, my lord, that is essentially the, my lord, he is permitted to put up a signage or hoarding is not there anywhere. My lord, there is this place which is in existence, that neither me nor him are disputing that. His right to put up a signage is what, my lord, is in question now. If that right to put up a signage is not there in the eyes of law, but he misinterprets the order of the trial court and then puts up a signage, is the court to be a silent spectator is the question, my lord. His right to put up a signage, as my lord's right to put it, that is the question, my lord, which has to be seen. This portion was left blank, my lord, as it is because, my lord, he did not have the permission, so on and so forth. Now, what the trial court does, my lord, is.
So now, what is status quo ante to this letter dated 29/3/2023? That should be again, that should be put back to that stage now then.
No, my lord, now what they are saying is the hoarding which
No,
you.
they were not, they have vacated it as per this letter.
The
This
first
letter.
floor portion they have vacated, my
No,
lord.
they should be again, they can have that position also.
No,
first
my
floor.
lord. What the trial court says is, I had granted you injunction based on the situation that existed then, which also was that there was no signage in this portion. You have put up the signage after I have granted an order of injunction by making wrongful use of that injunction. So therefore, I will not permit you to put up that signage. That is all that the trial court has done. Injunction is still continued. So therefore, now kindly see, my lord, para 12, what the court says is this, my lord. On the other hand, as rightly pointed out by the counsel for the defendants, as per their own documents, plaintiff which is produced at page 60, I am reading, my lord, para 12, my lord.
The parties to have to be fair.
Yes,
No,
my lord.
You enter, no, this letter is there, you are a signatory to that. You accepted that he can have, not trying to take advantage of all these technicalities.
Not technicalities, my lord. Question is, can a party come to the court, that to a tenant, my lord, who has agreed to vacate but does not vacate the entire property, my lord? Subsequent to this, the understanding was he will vacate the ground floor also.
Why did you permit him? Why did you sign this letter?
My lord, this we signed under the hope that, my lord, he will vacate the ground floor also, which he has not done, for which a suit is now pending for evicting him. All this is, my lord, arm twisting tactics on the landlord.
And
Now,
you are blowing hot and cold at the same time.
no, my lord, I am not blowing hot and cold. My lord, question is he entitled to put up the signage after he gets an order of the trial court? That is the question, my lord. If there was a signage, my lord, as on the date the suit was filed, or as on the date the order was passed, my lord, I will not tell.
Then why did you, when an injunction is granted with regard to the very same signage?
Yes, my lord.
Why did you keep quiet?
No,
That was the time you have to bring to the notice of the court.
I brought that is my application.
Not here. But
Not here,
you
my
have contested the earlier application.
Lord, once the order was passed, we told the court that we have no intention of evicting him forcefully.
No. Please come to the earlier order. What was your stand with regard to the board? Did you say that there was no board as on that day?
No, my lord.
Please come to the order, we'll see.
Yes, my lord.
Page number.
page number. My lord,
What is the
order.
order that is granted?
Yes, my lord, that my lord is at page number 58, annexure D, my lord. On IA number 1.
There was an injunction. So in respect of item number 2 of the scheduled property.
Yes, my lord, exactly.
That is the.
Let us
signboard
assume,
is
my lord,
also
it is there. I have not done anything to that, my lord. Now, what the trial court did was, don't interfere with their possession of that is the order. I have not done anything.
What is
What
that possession? What is item number 2 of the scheduled property?
item number 2 of the scheduled property, my lord, is the ground floor portion plus the space on the first floor.
Come to the schedule. Let's
Yes,
see.
my lord. Please see what the schedule says. That, my lords, will get at page number 36.
Yes.
All that piece and parcel of commercial property comprising of ground floor and signage in the first floor, totally measuring 2,300 square feet. This signage area, my lord, is they are claiming it to a part of their property. Now, court has said grant an order of injunction. I have not, my lord, interfered with their possession at all. Now, my lord, after this order is passed, they go and put up a hoarding in the first floor area so as to block that particular portion, and we go to the court and said,
You don't question this order.
this order I question.
Will not question this order.
No, I questioned it by filing 2 applications, my lord, saying that please look here, you have passed this order. We have no intention of forcefully vacating them. There is already a suit which is filed. We will vacate them.
Were you not given an opportunity while passing such an order?
We were given an opportunity.
No, court will again and again on the very same applications will go forward and backward.
Not
and decide.
backward, my lord. The question is, my lord, once there is an order of injunction.
What is the prejudice to you? You are a party to that letter.
Yes, my lord.
Where you have permitted him to have the signage there.
They were permitted to have a signage there, my lord.
Whether it is before or after,
Yes,
when
my
he's, as far as that signage is protected, how are you affected by it?
My lord, how my grievance was by taking an order of the court, my lord, they cannot alter the status which existed as on the date of the suit.
As far as that letter is concerned, you have not denied that, and according to that, they can have the signage there. Now, whether it is done before or prior to that, the court now, as far as that particular area is protected and he is at liberty and you are restrained from doing it, they can do whatever. There is no status quo. It is not an order of status quo.
It is not an order of status quo. Please see, my lord, what the trial court would say.
No, the trial court is, what kind of the orders passed by the court. There, it completely says that everything, the letter, and basing on that letter, the grants injunction, then why should this be done? Now, by looking at this order, how it appears is,
Yes.
what I understood while I was reading this order,
Where is it?
maybe the first floor is completely, now they've given the position to you. Now they have put up some wall on the first floor, which is obstructing your possession or usage of that particular place of first floor. That's why such an order is passed.
No.
Now, the crux of the issue is the signage.
Crux of the issue is signage, my lord. Signage means,
That's what they wanted. For that, they filed the suit.
signage, my lord, is, my lord, the place where the signage can be put up is one aspect. Signage being in existence is another aspect. Now, my lord, if they were to say that there is signage and there is.
They did say that you have removed it.
My lord, they have said it. Please see para 11 of the
They
plan.
said it. They have said it. They removed it.
Yes, my
and
lord.
now they
Now,
want.
therefore, my lord, that is entirely my argument. Now, having said that, my lord, I have removed it. Let us assume against myself, my lord, I did it. My answer is, my lord,
That's why they wanted an injunction against you, restraining you to from interfering with that signage.
Very well, my lord.
There is, court never said you maintain status quo. If that is, the court has ordered status quo, your argument holds good. But here it's not a case of status quo, nor the court had said, don't do it, don't do that. Court in fact tell them that you don't do anything with regard to their signage.
Yes, my lord, I am
Court
not.
never said they don't put up anything, don't do any further work. When they are permitted to, when there is a injunction against you and they are permitted to use it, they will do it what they want to do.
My lord, that's the order permit, that was the question, my lord, which we asked the court. My lord, we will not interfere with them is one aspect. We have not interfered till today. The second aspect is, my lord, can they take advantage of that and, my lord, put up a new
Yes.
structure?
If that's the argument, then I'll pass orders. If anything else, you can.
Yes, my
submit.
lord, that, I'll
If,
just
if
point.
it is the argument, why it can be done, I'll
No,
dictate
no,
the
no,
order.
not that, my lord. I am not saying why it is done.
I am not saying anything. If that's the only argument you're putting forward, for that, that will pass an order. Otherwise, if you have any other submissions, you can make.
My lord, please see. My lord, what we have said, please turn to my lord,
Yes.
page number 63.
Yes.
My lord, all this, my lord, was done. Therefore, how the protection was given, my lord, is to be seen in light of this. My lord, in fact, several letters which are there, my lord, they have not produced. They have produced it only selectively. In fact, the entire set of records must be produced to show, because, my lord, now their argument, my lord, as I understand, is that the court cannot undo what it has already done. Well, that has to be understood in the context of what were the contentions that were put forward and what were the documents that were available. Now, my lords, if my lords were to kindly see para 63, sorry, my lord, page 63.
In the light of the order that is already passed, the court cannot afford to give all these findings at page 63 or 64.
Then my lords may just have it tomorrow. I will just take instructions as to what is to be done. My
Tell your client that the appeal will be allowed.
Just
Yes.
have it tomorrow, my lord. I will just.
Tomorrow.
Yes.
My lord, just one quick submission. The fact that they're saying that BBMP has pulled the signage board down is a false submission, and it's
So it will not have any significance. The
Significance.
BBA has pulled, they have pulled. Yes.
great.
Heard both the councils at length. Land council, the respondent seeks time to get instructions. Post this matter tomorrow.
Grateful.
Cell number 19,
Appear for respondent.
appellant. Pin for appellant. Manjunath T,
Appear for respondent.
Deepak C.
Pin for appellants. Put for declaration, position and registered gift deed dated 8/3/2018, executed by R1 in favor of R2 is not binding on the
Suit
plaintiff.
is for declaration.
Suit for
You are the
declaration,
plaintiff.
possession.
You are the defendant.
I was the plaintiff. I am the
Hmm.
plaintiff before the trial court.
Hmm.
Suit for declaration, possession and registered gift deed, not binding on the plaintiff share by law. We are the plaintiff before the trial court. And IA number 1 under order 39 rule 1 and 2, not to alienate the scheduled property.
Hmm.
My contention, my lord. Initially, the trial court has passed injunction order. After appearance of the parties or as defendants, they have filed the IA number 3 under order.
That is vacated.
My lord?
That is vacated.
Yeah, that was vacated. my lord.
Yes.
Yes, my contention is, my lord,
Hmm.
my father, there is no dispute with regard to the partition, my lord. It undisputed fact partition has been effective prior to that.
Please come to the cause title at page number 14. You sought for partition?
No, sir. Declaration, possession and gifted not binding on the
Come, who are these who are the plaintiffs? What is the relationship?
relationship, my lord.
They're all children of late
Yes, ma'am.
Chikkatimmaya. And who are the defendants?
Defendants, children of my elder uncle's sons, my lord. Children of my elder uncle, my lord.
Hmm.
Land was granted in the year, it is inam land, my
Before we go into all this, please come to the plaint.
plaint, madam.
Which page?
Page number 68, my lord.
Page number?
No, no.
There is no 68 in your papers.
In the objection, my lord.
Same case you have given or some other case?
My lord. Wrongly, it has been numbered, my lord, 28.
64 is the plain.
Wrongly it has been numbered.
Yes.
Para number 3, my lord. Sri Motaya of Vadalli had 5 sons by name Dasappa, Timmaya, Venkatappa, Basavaya and Patel Timmaya alias Chikka Patel Timmaya alias Chikka and Srimati Papama having 2 sons by name Shantaraju and Puttesh. That is the plaintiff number 2 and 4. And 3 daughters by name Sharadama, plaintiff number 1. Srimati Saraswati, plaintiff number 3. Lakshmama, plaintiff number 5. Srimati Papama died on 4/7/2021. This genealogical tree manner. Para number 4. Patel Timmaya Chikkatimaya, son of Motaya, was the chairman of Vadalli village, Tavarekere Obadi, Bengaluru South Taluk. He was cultivating the land bearing so on so forth, survey number 14, 15, 16 and other land. For para number 5, my lord. Vadalli village was a ex-Jodi village under the Jodidar. After Inam Abolition Act came into force, Patel Timmaya alias Chikka Timmaya filed an application individually before the Special Deputy Commissioner for Inam to regrant the land bearing survey number 14, 15, 16 and other land of Vadalli village in his favor. The Special Deputy Commissioner for Inam, after conducting the detailed inquiry, granted the land bearing survey number 14, 15, 16 of Vadalli village in favor of Patel Timmaya alias Chikka Timmaya and issued the endorsement on form number 7. And next, my lord. Para number 6. It is relevant. Para number 8, it is mentioned, madam. Para number 8 of the plain.
Yes.
Defend number 1, Sri Dodda Kempaya and his brother Chikka Timmaya, children of Venkatappa. That is the elder uncle children, my lord. Since it is not partition, we have not mentioned, my lord. Then para number 6, my lord. By virtue of the endorsement and order passed by the Special Deputy Commissioner for Inam, Patel Timmaya, Chikka Timmaya became the absolute owner of the land bearing survey number 14, 15, 16 of Vadalli village. The said land was the self-acquired property land of said Patel Timmaya, Chikka Timmaya. He was in peaceful position and enjoyment of the said land as absolute owner along with his family member. The concerned revenue authorities have mutated.
When is this suit filed?
In the year 2022, my lord.
Yes. Read further.
My lord.
Read further.
Para number 7, my lord.
Yes.
Patel Timmaya alias Chikka Timmaya died in the year 1986, leaving behind his wife and plaintiff as his nearest legal representatives. After his death, Srimati Papama and plaintiffs are in peaceful position and enjoyment of the property acquired and left behind by Patel Timmaya and Chikka Timmaya as absolute owners. The said properties are the self-acquired absolute properties of Srimati Papama and plaintiffs. At the time of death of Patel Timmaya alias Chikka Timmaya, Papama was uneducated and had no worldly knowledge and plating for a minor. Para number 8, my lord. Defend number 1, Sri Dodda Kempaya and his brother Chikka Kempaya, that is the children of Venkatappa, were educated and had knowledge of documents related to the family properties of Motaya and Sri Patel Timmaya alias Chikka Timmaya. During the lifetime of Sri Motaya, he and his children were divided their family properties by orally through Jubane Vibhaga Patra in the 1970s. The concerned revenue authorities have mutated the revenue entries in their favor, whatever share allotted to them under the Jubane Vibhaga Patra. Para number 19. The Dodda Kempaya and Chikka Kempaya filed a false representation before the revenue authorities to mutate the revenue entries with respect to the land left behind by Sri Patel Timmaya alias Chikka Timmaya in favor of all children of Motaya without consent and knowledge of Srimati Papama and plaintiffs. The revenue authorities, in collusion with the Dodda Kempaya and Chikka Kempaya, without conducting an inquiry and call for objection to the interested parties and without knowledge and consult of the legal representatives Sri Patel Timmaya alias Chikka Timmaya, passed an imposed mutation order while its order dated 30/7/1994 in MR number 13/1993-94 with respect to land bearing survey number 14, 15 and 16 in favor of Dodda Kempaya, Chikka Timmaya and Srimati Papama. On the basis of the impugned order dated 30/7/1994, Dodda Kempaya got mutated the revenue entries in his favor with respect to the land bearing survey number 14 measuring 2 acres 12 guntas and Chikka Kempaya got mutated the revenue entries in favor with the land with respect to land bearing survey number 14 measuring 38 guntas out of 5 acre 24 guntas
The plaintiff filed a separate suit against Dodekempaya, so and so. That is also pending, my lord. And next paragraph 10, my lord. After they came to know about the said revenue entries, Papamma filed a revenue appeal in RAS number 47/96/97 before the Assistant Commissioner, Bengaluru South Tal, by challenging the MR number 13/93/94. The Assistant Commissioner, after conducting the inquiry, passed an order on 27/1/1994 by directing the Srimati Papamma to file a civil suit before the jurisdictional court. Parallel 11, madam. The order passed by the Assistant Commissioner was not intimated to Papamma under LRs. Papamma was in involvement of her family such as livelihood, giving the education and performing the marriage of children. Since was not aware of
The court had dismissed your application for injunction as you have not come to the court with clean hands.
only
That's
the
the only
dispute
ground.
is with regard to the name of the my father name, my lord. It's Patel Timmaya alias Timmaya. Their objection is it is Chikka Timmaya. And then MR 13/1997, they in the MR 13 before that they have given the even defendant number and his brother has given the representation before the Tahsildar, my lord.
Why did you take two inconsistent stands in two suits?
That was this one. In support of my this one my contention, we have produced the MR, my lord.
Not all that. Why did you take there are two suits. In two suits, you have taken two different contentions.
Yes, ma'am. It
Court
has
has to
been
call for everything. Then the equitable relief of injunction cannot be granted to a person who has not come to the court with clean hands.
But
You're not
in support
entitled.
of my application, we have produced the MR number 13, but that
You
court
please
court
tell
is
the-
not considered
That's
this one.
what is not about other MR numbers. Why did you say so? And even before this, the court also, you have argued on that. The court was right. Why should the court come to the rescue of a litigant who is
That
not
was
fair
decided
to
in
the
the
court?
tribal issue, my lord. That was decided that during the trial, it has to be decided whether it is.
No,
the
that
name-
is with regard to the perjury proceedings, which will be decided later. Now, when when there is a tribal perjury issue, how are you entitled for injunction? Yes, what is?
My lordship, the entire land in the Wadalli village, it was conferred on the Patel Timmaya. The appellants themselves have admitted their contention in page number 17, my lordship. I have filed statement of objection.
What is your father's name?
I am for respondent. My
What's your father's name?
Venkatappa, my lord.
Hmm.
I am the son of Venkatappa. Respondent to number 2 is my daughter. It is clear from their evidence in the OS number 832 that appellant number 4, he clearly admitted himself, my lord, that his father, kindly go to page number 42, my
I
lord.
read it, I read the order.
There, he clearly admitted, my father, Chikka Timmaya, got 2 acres, 2 guntas in survey number 3, 14 guntas in survey number 22/5, 4 guntas in survey number 24/3, 1 acre 35 guntas in survey number 14. But here they are taking different contention, my lord. They are contending that entire 5 acres, 5 guntas is a self-acquired property of them. But in the cross evidence, they clearly admitted only 1 acre 35 guntas fallen to their share. And apart from that, my lord, there was one more LAC case. In that one, both Patel Timmaya and Chikka Timmaya were the claimants, my lord. These appellants, they
Where from you're reading the?
page number 46, my lord, statement of objections. Page number 46.
Yes.
It can be seen, my lord. Both Patel Timmaya and Chikka Timmaya, both were claimants. These appellants, they came as LRs of Patel Chikka Timmaya on record, not as Patel Timmaya, my lord. It clearly shows they have not appeared before this court with clean hand, my lord. They have appeared before.
Where from you're reading? I'm not able to find it in 46.
Statement of objection, my lord.
Forty-six is here only. What is the CRP?
CRP, we challenged the, since it was barred by law of limitation, my lord, we are challenged before this honorable court, and this honorable court dismissed that CRP, stating it's a trial issue, so it cannot be determined now, and I directed the trial court to dispose the matter expeditiously.
So
my
you're
lord.
referring to an award
Yes.
in LAC number
144 of 1997, my lord. In that LAC case, my lord, both Patel Timmaiya and Chikka Timmaiya were claimants, my lord. Patel Timmaiya was the claimant number 1 and Chikka Timmaiya was the claimant number 4. And these appellants came on record as LRs of Chikka Timmaiya.
What is the different relation between Patel Timmaiya and Chikka?
Patel Timmaiya is a elder brother of Motaya, a elder son of Motaya, whereas Chikka Timmaiya is a younger son of Motaya, my lord. And that can be seen from the family tree produced by these appellants, my lord.
Page number?
Page number 26, my lord.
26.
I have produced the family tree of the
Where is the petitioner's father's name? Appellant's father's name?
this one, fifth one, my lord. Chikka Timmaiya, wife name Papamma, children Sharadamma, who is appellant number 1.
Where are your names?
Son of Venkatappa, my lord. Third one.
Venkatappa.
Yeah. Dodda Kempaiya and Chikka Kempaiya, my lord.
Or the defendants?
Only Dodda Kempaiya is the respondent number 1.
Chikka Timmaiya is?
They have not made him as a party, my lord. He is not a party.
So what happened in this award?
This award, they claimed award as LRs of Chikka Timmaiya, my lord. They did not appear as LRs of Patel Timmaiya. They appeared for Chikka Timmaiya, which clearly shows both Patel Timmaiya and Chikka Timmaiya are different persons. For a malified intention, they have filed this suit just to harass respondents, my lord. And one more submission, my lord. Kindly peruse the page number 42, my lord. It is the cross evidence of appellant number 4.
42.
42, my lord. It is true that Mota Nayaka is my grandfather and he had 5 children. They are Patel Timmaiya, Timmanna, Venkatappa, Basavaya and Chikka Timmaiya. It is clearly mentioned, my lord. And kindly peruse the line number 6, my lord. Around 40 to 50 acres were granted. It is true that all the properties were
Same page?
Same page, my lord. Line number 6. Around 40 to 50 acres were granted. It is true that all the properties were partitioned between Patel Timmaiya and his brothers. This said partition was oral partition. It is true that in the said partition, Patel Timmaiya got, he clearly admitted both Patel Timmaiya and Chikka Timmaiya are different and Patel Timmaiya got separate portion. It clearly shows, my lord. For a malified intention, they have suppressed in this suit, my lord.
Submission, madam. Page number 37, he is not admitted in the witness box, my lord. During the cross examination, same thing is denied, my lord. Page number 37, the same objection, my lord. But it is in Kannada.
I have translated that copy, my
It
lord.
is not, this has not been translated. Whatever he has denied, he has not translated. Whatever is
45,
accepted,
page
it has
number-
been.
page number-
37, my lord. Nipi 19 ಮತ್ತು 21 Patel Chikka Timmaiya ಅಂತ ಬರೆ-
Leave that, whatever the.
That is not translated, it is
Now,
submission.
please come to the order. Any whatever that is recorded in the order with regard to your admissions and your denial is right or wrong.
That's what he has not admitted, is the Chikka Timmaiya is my father, my lord. He has admitted my father was the Chikka Timmaiya alias Patel.
Please understand, again, if now the court asks for a translation from the registry, then you will be in problem. Now, please come to the order, impugned order.
That
Para
was
number
not
12.
considered my.
No, please look at it. Para number 12. The plaintiffs have taken 2 different contentions in 2 different courts. The defendants have stated that the plaintiff has produced affidavit to the extent saying that Patel Timmaiya and Chikka Timmaiya are 2 different persons. The defendants have further stated that the plaintiffs have taken that the Patel Timmaiya and Chikka Timmaiya are one and the same person. The defendants further submit the said pleadings so the plaintiff would effect the so and so.
In this plaint, we have not taken my lord. Earlier it was my.
That's what the court is
That's-
saying. Are you permitted to
I-
even with regard to the identity of the people also, every suit, new contentions you cannot take.
That was mistakenly, it has been taken, my lord. And my.
Please come, there is nothing wrong with that.
MR 13 has not been considered by the trial court, my lord. They
The-
themselves have given the representation, my lord, kindly, my MR 13, they are claiming under MR 13, my lord.
That is not their suit. That's
It's
your
our
suit.
suit, we have given but they have given
Agree
the
with the orders
representation
passed
before the
in-
Tahsildar, my lord. It is clearly stated that
1, 3 and 5.
it's
Invoice from 6
Permitted.
of 2022. Dated 16 February 2024. The appellant plaintiff is before this court. The suit is filed seeking the relief of declaration that the plaintiff is the absolute owner of the suit scheduled property, and further seeking recovery of possession, and also to declare that the gift deed dated 8/3/2018 executed by defendant number 1 in favor of defendant number 2 is not binding on the plaintiffs. In the suit, initially they have filed an IA seeking injunction that came to be allowed. Thereafter, the defendants have filed an IA seeking to vacate the said injunction. The court, by order impugned, had allowed the application filed by the defendant and vacated the injunction that is granted in favor of the plaintiff. Further, I number 5, which is filed by the defendant to initiate proceedings under section 340 of CRPC, is also rejected as premature. It is a case of the plaintiff that the plaintiff's father is the owner of the suit scheduled property. On the death of the plaintiff's father, the defendant in number 1, suppressing the 2 facts, had got mutated their name in the revenue records, and thereafter fraudulently gifted the property in favor of defendant number 2. It is the case of the defendants that the plaintiff number 2, along with the mother and plaintiff number 4, had sold their shares in favor of one S.A. Aziz in the year 2002-2003. Chikka Kempaya, brother of defendant number 1, had sold his share of 38 guntas in survey number 14 to S.A. Aziz, and the revenue entries were mutated in the name of S.A. Aziz. The revenue entries so mutated were wrongly entered due the stray entries in column number 12 of the RTC, reflecting the name of Papamma, based on which the plaintiff has approached the court. It is a case of the defendant that the property is validly transferred to defendant number 2, and the interim order already granted needs to be vacated. Thereafter, the court has also considered the plea of the defendant with regard to the perjury committed by the plaintiff. Thereafter, with regard to the stand taken by the plaintiff in voice number 832 of 2014, that Chikka Timmaya and Patel Timmaya are 2 different persons. And also the contention, and also it is the contention of the plaintiff, present plaintiff in the earlier suit is Chikka Timmaya and Patel Timmaya are in the present suit. They have taken the contention that in OS number 832 of 2014, Chikka Timmaya and Patel Timmaya are 2 different persons. In this case, Chikka Timmaya, and according to them, Chikka Timmaya and Patel Timmaya are the same persons. The court had perused the plaintiff exhibits and depositions, which shows that the plaintiffs have themselves stated that they are 2 different persons. Basing on this, the court had come to the conclusion that the plaintiff has not come to the court with clean hands. the court considering the judgments of the Honorable Apex Court, wherein it is held that party who comes to the court with unclean hands is not entitled for the equitable relief of injunction. And further, the court felt that the plaintiffs have not made out a prima facie case balance of convenience is not in favor of the plaintiff. And there is no case of hardship, and accordingly dismiss the petition and vacated the order granted by the vacated the injunction granted by the court. Agreed thereby the appellant is before this court. Learned counsel appearing for the appellant submits that the appellants have filed several documents to show that they are the owners of the property, and the said applicants, the court had failed to consider all these aspects. The particularly MR
13 of 9. 13 of. MR 13, madam. 93-94, madam.
it is submitted that MR 13 of 1993 was not considered by the court. It is submitted that as their father, as they have been continuous possession of the property, have as they are the absolute owners of the property. The court ought to have considered all these issues. Next, when counsel appearing for the defendant submits that right from the beginning, they have been the appellant. The right from the beginning, the appellant was coming before the court with suppression and misrepresentation of facts. It is submitted that he has drawn the attention of the court to the land acquisition proceedings, the examination of the plaintiff in the other suit. Relying on all this, then counsel submits that the plaintiff had taken different stands, and with suppression and misrepresentation, she had approached the court, and the court had rightly dismissed the application seeking injunction. Next para. Having heard the counsels on either side, there is a material on record. This is a suit filed for declaration and also the relief of injunction, recovery of possession and injunction. Now, the injunction that is sought is not to alienate the properties, and also the other relief is the gift deed or sale deed.
If they did,
Gift deed is not binding on them. Which is the date?
18 to 2018.
2000?
8/3/2018, my lord.
Gift deed dated 8/3/2018. And it is also an admitted fact that there are defendants or in possession of the property. The plaintiff, when the plaintiff was seeking injunction, has to come before the court with clean hands. They cannot, they can't afford to suppress or misrepresent the facts. The court, looking at the earlier suit, the stand taken thereon, and the present suit, has categorically come to the conclusion that the plaintiff had come to the court with clean hands, and he is not entitled for the relief as prayed for. This court, this court is of the considered opinion that the trial court had rightly given a finding basing on the material before the court, and this court, while exercising the jurisdiction under Article 227 of the Constitution of India, do not find any reasons to interfere. Accordingly dismissed.
Then number 20, Jacob LS for appellant. For Kavita respondent.
Appellants. Defendants first appeal. Suit for declaration, injunction and.
Why on the last occasion it is adjourned?
Was to be heard in detail and that's why it was adjourned.
Yes, yes.
Suit is for declaration, injunction and for cancellation of the sale deed executed by the defendants 1 and 2 in favor of defendant number 5.
What is the sale deed dated?
Sale deed is dated 11/12/2023. 10 days after execution of the sale deed, the suit is filed by the plaintiff. The
Is the injunction sought?
injunction sought was for restraining the defendant number 5, the purchaser,
From
from
further alienating.
alienating the suit scheduled property.
What is the case of the plaintiff?
Case of the plaintiff that they are the grandchildren of one Badragiri,
They are the,
grandchildren
Ah.
of the Badragiri. And they are in possession of the suit scheduled property. The defendants have no manner of right, title or interest and they have alienated, so the sale deed has to be
what is
cancelled.
the source of title?
Source of title is their grandfather. So is,
Where from you
Eh,
got?
it was purchased, their case is that it was purchased under a registered sale deed date in the year 1963.
60,
31, 1936.
50,
31, 1936.
31, 19?
31, 1936.
Defendants
With
case,
respect to property bearing survey number 79.
Hmm. Hmm. Yes,
the defendant's case is that the so-called Badragiri is not, and the plaintiffs are in not at all related.
Hmm.
It is the one Chude Gowda purchased the property in the year 1936. After his death, his son Badragiri came into possession. The property was mutated to his name. He also had a son called as Chude Gowda who had 3 children, and the defendants 1 and 2 are the children through one of the sons of said Chude Gowda.
now what about the revenue increase?
Revenue entries after the death of father of the plaintiff. The defendants 1 and 2 gave application to Tahsildar Kanakpur for mutation entry changes.
Which year?
In the year 2014.
Till 2014, this stands in the name of?
It was standing in the name of Badragiri, the grandfather of the defendants 1 and 2. That is the case. So when the application was given for change of kata after the death of their father and mother, defendants 1 and 2 made an application to the Tahsildar Kanakpur, and one Pune Gowda of the same village, he gave objections for change of kata. That objections were dismissed by the Tahsildar Kanakpur. After perusal of the documents, the Tahsildar ordered for revenue entries to be mutated to the name of defendant 1 and 2. That was challenged by the said Pune Gowda before in an appeal before the assistant commissioner. The appeal also came to be dismissed. And again, he files a revision petition before the district commission, the deputy commissioner. I am given to understand as on date, the said revision is also dismissed. The very same Pune Gowda in the year,
Petition filed by them is dismissed.
they are not doing anything right from the year 2000.
File the revision.
Revision was filed by the said Pune Gowda, a third party. Parallelly, this Pune Gowda, he files a suit against my father for declaration, injunction.
No, when from 2014, somebody else's name is reflected. in the
Somebody else is
records.
litigating and we are defending.
No. What did you do from 2014?
2014, we have been resisting the revenue courts, whatever is happening.
What happened?
We are
Okay.
defending. I will come to it. As on date, the revenue entries made in my favor still upheld by all the revenue authorities.
No, your name-
Parallelly,
Your name stands in the revenue records.
yes. Defendant number 1 and 2's name has been mutated already in the revenue records. Parallelly, the very same Pune Gowda files a suit in the year 2004 against my father for declaration and injunction. The said suit came to be dismissed. After the death of my father, again the very same Pune Gowda files another suit for declaration injunction against defendant 1 and 2. Earlier it was against the father, thereafter it is against the children. In the very same suit, he himself files a suit application under Civil Rule 10 and takes the plaint back for presenting the same
What is the nature of the property?
agricultural property.
Yes.
My lord, what he is submitting, it is completely false. There is no relationship with respect to this plaintiff and the defendant with respect to Punnegoda, who has filed some litigation before a Tahsildar and EAC and Deputy
No.
Commissioner.
Even forgetting the relation, as far as the suit property is concerned, the
It
revenue
is
entries-
belongs, it
their
is,
revenue entry stands in their name
no.
as
you-
of now.
My lord.
Even on the
kindly
date of
see-
filing the
kindly
suit, it
peruse
was
the
standing in
RTC,
Huh?
which stands in the name of Bhadragiri, who is the father-in-law of the first plaintiff. Till 21, 22, the name of the Bhadragiri is found in the RTC. Whereas this first and second defendant, by submitting false information before the revenue authority, by colluding with them, they got changed the kata in their name
When,
during 2022-23.
till 2022, Bhadragiri's name is only
Yes,
there.
in Bhadragiri, that is the father-in-law of the first plaintiff. Then immediately after getting change of the kata, they disposed of the property in favor of the defendant number 5 during
Yes.
23.
Heard in part, post this matter on the top of the list tomorrow. As a first matter, we'll dispose it of.
But
Yes.
tomorrow, my lord, tomorrow it is personal inconvenience. Kindly it may posted.
Posted
either
on
13 or
20th,
17th. 17th.
20th.
Well, my.
29. Till number 21, urgent 22. Ashiram, Bihar.
Yes.
The application filed by the appellant sought for a probate came to be dismissed solely on the grounds that, my lord, the executor name is not found in the will. That is the reasoning. Your lordships kindly see the reasoning in page number 16 onwards.
Who has executed the will?
My father was executed a will, registered will.
You have no brothers, sisters?
No, brothers, sisters, they have taken a paper publications. Already paper publications has been placed before the trial court.
No, you do. You are the only son.
My brothers are there, sisters are there, my lord. The exclusive rights of my father, who are during his lifetime, you are executed a.
No. Why? Respondents are shown as nil.
Because of this, they are not interested. Exclusively, the will is executed in my favor. Therefore, I sought for probate.
You sought, nobody like to know or otherwise.
If you are having a rights over the property, my lord, let them be filed, and therefore are taking a paper publication for that. That is not a contention before the trial court. But the
No. Please tell the court, only court what
Please,
what
please,
the court wants to know is, who are the proper and necessary parties in a suit of this nature, in a petition of this nature?
probably my probate court may not look into all the members of the family members. So only the execution of the will has been proved. It is ultimately probate court grant a probate petition.
So no.
It's the law.
Let's see the
So
So nobody, no, except you just take some document. You will not, none else are the parties, and you will file it, and basing on that, the court will grant.
I take a paper publication. I take a paper publication for that.
Paper application for what?
For notice. If you any have interested or objection to file an objection to my contesting the probate petition before the trial court.
We'll have it some other day. Post the smart on 20th, yes,
22nd onwards may be taken.
20.
22nd onwards.
27,
Please, ma'am.
yes.
Nizam Abbas.
No representation. Post this matter on November 25th. Yes, next.
Till number 24.
For appellant, my lordship. Notice has been served in this case. my lord.
Sir.
Served.
Yes.
Post this matter on 20th. Yes, next.
Till number 25.
This is on November 12th.
Number 26.
I am for appellant in this
No
case, madam.
representation.
I am for appellant in this case, madam.
20.
Abdul.
Yes,
I am for
20
appellant in this case,
26
madam.
also on 20th, yes. Yes,
Till number 27 urgent. Till number 28. Gopal Krishnamurthy.
non-compliance of office objections raised.
They have filed on some application wherein that objection is raised by registrar.
Huh?
For that, their application, the objection is raised.
There is an order in your favor in this?
Yes, my lord, interim order is there.
Pose no representation for the respondents. Pose this matter on 20th of November,
Please, interim order.
8th of November. Interim order earlier granted is extended.
Great.
Next 29.
29, MR Ire Method, Kapil Dixit for respondent.
This also. This is on October, no representation, October 29.
Sale number 30,
Matter pertains to granting of maintenance. Now both the doctors are together. Therefore, the likelihood of reporting the settlement. This may be called on 1st of October.
It is submitted that there's a likelihood of settlement between the parties. For this matter on 14th of October.
sale number 31. SG Bhagwan,
Where is a respondent? It's a fresh matter. How much is granted?
8,000.
8,000.
10,000. Now 10,000 is about 125%.
What is income of the husband? Husband's income.
Yeah, all the documents to show that he has income to meet his actual needs. Why actual needs only? Why is and children? So far as the children are concerned, they are teenagers. So that is not. And apart from that, I've been depositing 15,000. I am prepared to deposit 50,000 also in a week, within 3 days. On the 13th.
What is the income of the husband? That's what I asked.
He does not have any regular income. He had a tenant by name PV Mohan. He was paying 1,600 rupees per month. That
What is the age of the petitioner?
now petitioner is about 59 now. Notice may be ordered, even emergent notice.
Issue emergent notice to the respondents.
Please,
Yes, next.
sale number 32.
I have prayed for stay also. Temporary.
In that case, there should be a conditional order. Then the court has to hear. Issue emergent notice. Yes.
Sale number 32, Dheeraj AK. 32, Dheeraj AK for petitioner.
No representation. It's RPFC of 24. Post this matter on 20th Friday. Yes.
Sale number 33, disport 34, Tyagaraja B.
Yes. Oh, that matter, where is she? This also on 20th. No representation for the respondent, counts for the petition is present.
Sale number 35. MB Inamdar.
For respondent. The honorable court ordered last time that you can argue the merits of the case, then you will consider for.
It's also on 20th. Yes.
Sale number 36. Vinay Vaiti for appellant.
No representation. Post on 15th of October. 15th of October. Yes.
Number 37, adjourned. 38, Kalyana.
Filed application for extension of interim order. Interim order was granted by inadvertently and oversight. I failed to get the interim order extended. Therefore, I filed an application for extension.
When was it granted? When was it not extended?
My lord, the interim order was granted. My lord, on 9/5/2024. 2024.
24.
Please.
Oh.
On 13/6, the interim order was again extended. My lord, on 30th August, the matter was listed and the interim order could not be paid.
That's the only day.
Correct.
We'll extend it.
An early date may be fixed for.
Yes, we'll hear it. MFA of 2024, the I number 1 of 20,
2 of 24.
2 of 24 is fine.
We have filed this statement of objections also. The matter can be heard.
Taking extension of interim orders. It is submitted that this court had granted stay on 9/5/2024, and thereafter it was extended on 13/6/2024, and the matter listed on 38/2024. On that day, they, by inadvertence, they couldn't ask for the extension of the interim order. The same is not extended, considering the same. IN number 2 is ordered, and the interim order has granted on, has extended on 13/6/2024, is extended till the next date of hearing for this matter on 14th of October.
Earlier, 26th or 27th.
30th.
Yeah, but 27th.
Huh?
27th,
27th not possible.
26th.
There are so many matters, your matter won't even reach, just you are asking.
Another
that,
matter is listed on
for-
30th, 29th,
24/9,
29th,
24/9, sir.
24/9. Okay.
Yes.
Number 39,
39, I appear for the appellant, my lords.
What are the
Well, it's-
typed copies of
Well,
annexes C and C1?
That I'm not relying on, my lords. That I'm not relying on that, my lords.
You will comply with the objections?
No, my lords, that I am not relying on those documents. My lords,
Oh,
may I
that's why you
explain?
not, then if you're not relying on something, why do you unnecessarily file and this office objections?
Well,
Then you
that-
shouldn't have
that-
filed. It
I have
is
sought for the
submitted that,
dispensation of the same, my lords.
It is submitted that the appellant is not relying on annexure C and C1. C1. As such, the filing of the typed copies may be dispensed with at the risk of appellant dispensed with. IA 2 of 24 is filed to condone the delay of 30 days. Notice to the respondents. Yes,
number 40,
Grateful, my lords.
yes, 40 notice,
Appellant, man.
Till number
There is a 11
41.
days delay in the.
notice 41.
the 42. Till number 42,
42 appearing for petitioners. Notice may kindly be issued because the wife's petition for lordship, where her petition for under section 125 is rejected.
Notice to the
number
respondents,
43,
post after service of notice.
Mr. Ramesh,
43. It's
husband's petition, my lord. 10,000 rupees has been awarded, my lord. He has no source of income. As he's the petition physically handicapped and petition for
Is it a handicapped person?
yes, handicapped.
How much is granted?
10,000 rupees has been granted, though his income is
And counsel for the petitioner submits that the trial court had granted an amount of rupees 10,000 as maintenance, and the petitioner is a physically handicapped person. All these aspects were not considered by the court. Considering the submission, there should be stay of all further proceedings. On the, how much you will give her?
2 to 3,000.
There is no income.
In fact, the learned
There shall
judge,
be stay of all further proceedings, petition, issue notice to the respondents, post after service of notice.
till
Yes,
number
44.
44.
she's Muslim Muslim. Much obliged.
For the petition.
What is this IA taking suitable action against petitioner?
Yes, ma'am.
Yes, filed an application to take
said-
action under perjury. In fact, I should have filed that application. She has suppressed many things.
But 4:46, 4 o'clock, this perjury proceeding,
Yeah.
court is.
Nothing has been
not-
suppressed, my lord.
Friday, but on
Some
20th.
of the documents which have slipped out.
That we will see on that day, 20th,
29.
if you want to serve on him. Yes, 44.
44, 45. Final hearing, Cyril Prasad Payas. Abhishek Marla.
Short accommodation.
Next on final hearing matters, comes all under the whatever listed under final hearing. Let it go in November 5th.
Millards, in serial number 48, Millards,
Hmm.
there's an interim order, which was not extended on the.
If there are interim orders in all those matters, extend till the next date of hearing. Yes, next.
Passed over. Passed over matters in list 1, serial number 4. Passed over serial number 4.
My lord,
There is a response.
kindly,
Harshavardhan,
Yeah.
Shobha HK.
We'll have it on Friday 20th. My lord,
one submission, my lord. Kindly peruse the order dated 19/3/2024, my lord.
Yes.
There was a direction to respondent husband to file the affidavit regarding the transactions made with his girlfriend Soumya DV and with regard to
Objection,
his
sir.
present income, my lord.
I have,
Just a minute, I will complete. Yeah, even after the 6 months, they have not filed any affidavit with regard to that one. They are not giving any respect to this honorable court order, my lord.
I have filed my objections, your lordship. When did you file? You have not served on him. I served it on him, sir.
Objections they have filed, there is a specific directions to file the affidavit
What is it
regarding
he's referring to? Which order? Have you complied with or not? That
19
order?
I've complied
complied everything, your lordship. He has asked us to give us tell everything. What is that order first? What is the order? Tell the court.
19. May I read, ma'am?
Read.
It is submitted by the learned counsel appearing for the petitioner wife that in fact husband is running two beauty parlors and learned counsel
To file an affidavit. I filed.
regarding that one
When
and
did you
present
file?
income, ma'am.
What is the date of that affidavit? I filed it on 19/4, your lordship. Statement of objections. 19/4, I've submitted the objections. In that only I've stated, your lordship, that I don't. Affidavit also- Objection is different, affidavit is different.
Ma'am.
Pose this matter on 20th.
Ma'am,
But the order
I have
passed
it
by
on
this court on
13th.
Huh?
13th, ma'am.
Huh?
On Friday, 13th.
On third, when do you want? 13th Friday not possible, 20th Friday. Pose this matter on 20th by the time, as for the order dated 30/7/2024, an affidavit shall be filed by the respondent.
19/3/2024.
19,
19/3/2024, ma'am.
19/3/2024.
My lord, one submission. There is a arrears of 8 lakh rupees, ma'am. Now,
Lakhs. We'll see on that day. Yes.
I am submitting memo of
Submit
calculation.
everything with the court, file it in the registry, yes.
Cell number 8. Arun Govindraj,
Uh,
petitioner.
In 8.1, I am for the petitioner, your lordship, in 8.1.
It is adjourned long back.
8 is.
Which one is?
That because
Oh,
they
you
have
appear
sought-
for,
List 3,
This is the enhancement of maintenance amount, my lord. Kindly have it on 23rd or 24th of this month.
No, serial number 8, your lordship.
Number 8,
which day?
23rd, 24th, any date, my lord.
No, it is, now that matter is with regard to the custody.
That is the third list.
Huh?
That is the third list.
Third list, serial number 8.
Oh, third list.
This is the first list, my lord.
8.1, pose this matter on
23rd, 24th, any date, my lord.
30th.
Much obliged, your lordship.
11. J.M. Rajana Shetty.
I have given the message for the opposite side also, as my lord.
Oh, then. No, which case?
11, madam. 11.
Will we have it on Friday? 30th, 20th,
20th, no, my lord.
20th Friday,
24th, my kindly.
24th. No representation in the forenoon as well as on the afternoon on behalf of the respondents. Both this matter on Friday is.
24.
Yes.
Cell number, list number 3, serial number 8.
Kindly have it on 18th. Kindly have it on 18th. Wednesday.
No, there is an undertaking.
Yeah, we will file the details.
At the request of both the parties, pose this matter on 18th.
Much.
Yes.
Kindly. Serial number 32, I was here, my lord, up to 4:35. Fortunately, I was called.
What has happened? What happened?
None appears for the petitioner. It's a fresh matter, my lord.
When is it posted?
20th.
20th. Let it be on 20th.
Warrant has been issued against the.
Pose that matter tomorrow. Give the number to the court office.
Please. 32. Request your lordships to have it in fresh matter, please. It's a fresh matter. Sir.
Okay, launch.
My lordship, serial number 11, my lordship, of cause list 3.
What happened? Yes, what is?
My lordship, cause list 3, serial number 11, my lordship.
It's long back, it is over.
Already signed.
See, cause list 3, my lordship, not cause list 1. Cause list 3, my lordship.
Cause is 3 is at 2:30. I think you have not seen that.
It's called
My lordship, the matter was not called, my lordship. I've been online since.
2:30 it was called. It is listed at 2:30. You didn't see that?
Apologies, my lordship.
Yes. What happened to that?
My lordship,
It is posted to preliminary hearing on 29th.
Finally,
oblige, my lordship.
Yes.
this 3 serial number 1, your lordship. Lordship, apologies that I was, by the time I came, the
What happened? When tomorrow it's coming.
requires
For
some,
dismissal.
I would require some time because there's some translated copies that has to be filed.
No, it's like non-compliance of office objections. A week's time, take that. In same default order. One.
I'll be grateful.
Lord. Submission. Serial number 50. Parties are requested to come and meet in the chambers.
That will be in the chamber.
Yes. Parties.
Madam, serial number 31.
ಒಂದೇ ಒಂದು
Madam, serial number 31.
46.
Madam. Serial number 31 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದ?
ಇನ್ ಚೇಂಬರ್ ಮ್ಯಾಟ್ರ್ ಇದೆ ಎಲ್ಲ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ ನೋಡ್ಕೊಳ್ಳಿ.
31 serial number 31. Serial number 30.
ಚೇಂಬರ್ ಹತ್ರ ಹೋಗ್ಬೇಕು. You have to ರಿಸೀವಿಂಗ್ ಮೈನ್ ಪೋರ್ಟಿಕೋ ಇಂದ ಈ ಕಡೆ.
Serial number 31 madam.
31 ನೀವು ಯಾವ ಲಿಸ್ಟ್ ಸರ್?
ಅದು
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ SG ಭಗವಾನ್.
ಹೌದು ಹೌದು.
ನೀವು ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿಲ್ವಲ್ಲ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆಗಿ.
ಡೇಟ್ ಯಾವಾಗ ಕೊಟ್ಟವ್ರು ಮೇಡಮ್?
ಡೇಟ್ ಎಲ್ಲ ಇಲ್ಲ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ 45. That is all on 5/11. 46 ಅದು 5/11. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಇರೋದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ 136.
ಮೇಡಮ್ ಇದು ಅರ್ಧ
1510 ನೋಡ್ರಿ ಅದು ಇದು ಮಾಡಿ ತೆಗ್ದ್ಬಿಡಿ ಆರ್ಡರ್ ಶೀಟ್ ತೆಗ್ದ್ಬಿಡಿ
ಡೇಟ್ ನಾಳೆ ಕೊಡ್ತೀನಿ.
ಅದೊಂದು ತೆಗ್ದ್ಬಿಡಿ.
ಯಾವ್ದು 32.
32
ಅದು ಬೇರೆ ಕೊಡ್ಬೋದು.
ಏನ್
ಮೇಡಮ್ ಹೇಳಿ ಮೇಡಮ್ ಸೈನ್ ಆದ್ಮೇಲೆ ಮಾಡ್ಕೊಡಿ ಮೇಡಮ್. ಇಲ್ಲ ನಾವು ಪ್ಯಾಕಿಂಗ್
ಧೀರಜ್
ನಾಳೆ ಬರ್ತಾ ಇತ್ತು ತಾನೆ. ನಾಳೆ ಸಬ್ಮಿಟ್ ಮಾಡಿ.
10/9 at the request of petitioner.
ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೇನೋ ಅಂತ ನಾನು ಅನ್ಕೊಂಡೆ. ಹೋಗಿದ್ದೀವಿ ಅಂದ್ರೆ